Good morning, everyone. Welcome to the second day of our fall oral argument session here in Pittsburgh. As you may know, because I say it all the time, the Pennsylvania Supreme Court is the oldest appellate court in North America. Our roots date back to William Penn's Provincial Court of 1684, thus his picture, and the Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722. Last year, we celebrated the court's historic 300th anniversary in Philadelphia. We sit today in the City County building, which is a 1917 granite Art Deco building designed by renowned local architect Henry Hornbostel. It's truly an honor for our court to sit and work in three beautiful courtrooms in Philadelphia, Harrisburg, and Pittsburgh. I wanted to welcome today some students from the 8th grade American History class at South Hills Catholic Academy in Mount Lebanon. Would you students stand so that we can acknowledge you? Thank you for being here. We're glad that you were able to join us. I know your teacher, Mr. Matthew Schweck, is with you, and the visit was arranged by attorney Jonathan Bruno in his role as the co-chair of our Pennsylvania Bar Association's Young Lawyers Division for Zone 12, which is Allegheny County. So kids, we're glad you're with us. We hope you learned something today, and it's really up to these attorneys to decide whether any of you might have a future in the law. So I hope that you learn something while you're with us. Please be seated. Before we hear the first case, I would like to remind counsel of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case. You may then begin by stating your name and the party you represent and introducing your co-counsel, if any, to the court. The justices are familiar with your cases, so I ask that you avoid any unnecessary recitation of the facts or the procedural history, and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for particular issues. In cases in which there are multiple parties represented by separate counsel, you should avoid repeating the same arguments as prior counsel. I remind you that in our court we do not permit rebuttal. Please try not to interrupt the justices when they're asking you a question. A justice's question is not designed to trip you up. Rather, it indicates there are particular issues that we want to explore further. While we have no set time limit for argument in this courtroom, I will advise counsel when the court is satisfied that all its questions have been answered, and at that time, I ask that you conclude your argument. Mr. Minner, please call the first case.
Commonwealth of Pennsylvania versus Philip Walters, representing Mr. Walters, Mr. Robert Butner, representing the Commonwealth, Ms. Deborah Albert-Heiss.
In this case, a pathologist offered his opinion at trial that the victim's cause of death was strangulation by history. This opinion was not based on specific medical findings, but on a statement by another testifying witness. We are asked to determine whether the pathologist's testimony should have been excluded because, number one, it failed to comport with the requirement that an opinion on cause of death be rendered within a reasonable degree of medical certainty, or two, it improperly bolstered the credibility of the other testifying witness. Good morning.
Good morning, Madam Justice. May it please the court, I'm attorney Robert Butner here for Mr. Walters. And before I begin, I'd like to say I apologize for stepping up to the podium before my case was called.
Well, you couldn't have known that I was going to say what I said until I said it.
Thank you. Your Honor, normally a body offers clues that a competent medical examiner can read, interpret, and develop an opinion from. But when the body is so decomposed, such as in this case, and offers no clues, the medical examiner can't take someone's word that it happened a particular way and say, yes, that's the way it happened. Science doesn't allow that. Our rules do not allow that. Rule 702 or 702 and 703. As to the cause of death, Dr. Ross, in this case, testified.
Let's be clear, if I may interrupt you. We're talking about the medical cause of death, correct? Which should be based traditionally on medical evidence.
Medical evidence, correct, Your Honor.
Okay, go ahead.
And scientific at that.
Correct.
So at the time of the trial, Dr. Ross honestly stated that if I looked at the body alone, without history, it would have been an undetermined death. Now, the page numbers in my brief, I could tell you from the top of my head, that comes from the October 26th transcript, but I can't tell you the particular page. It's 34.
We have it.
Here, the history upon which Dr. Ross relied was neither medical or scientific. It was an allegation. An allegation, granted, that the Commonwealth put forward, but came from Miss Bell, claiming that Mr. Walters had committed a crime and this is how he did it. This wasn't a patient who went to a doctor and provided a history. It was a third party providing the background of what may or may not have happened in the death of Miss Lawrence.
And even the pathologist himself, Dr. Ross, admitted that there was no anatomic indication that she was actually strangled.
Correct. And I'm going to get to that in a bit more detail, only because it plays into Rule 702 and 703, as well as my assertion where this court granted aliquotter that the Superior Court overlooked that. So I have to mention it. Today, what I'm seeking, Your Honor, on behalf of my client and probably any defendant facing this type of case, is a balanced application of Rule 702 and 703, so that there is not testimony from forensic pathologists where the opinion is reached exclusively on non-medical allegations, and where the body is so decomposed that no objective medical findings can be made to rule in or out a cause or manner of death.
Counsel, if I may, what we have is a medical expert that indicated, or let's begin with the factual basis.
Yes.
The allegation from the co-defendant is that the woman, after she was allegedly beaten and strangled, she was hit with a hammer over the head, strangled. They tied rocks on her arms and legs and dumped her from a 30-foot bridge into the water. The medical examiner said he testified the skull, which was unremarkable, no indication of any bone trauma caused by a hammer. They ruled out death by trauma to the head. They indicated that while the torso and the body was decomposed, there's still some physical flesh left, and that indicated no broken ribs, things of that nature, to indicate that the fall, in fact, caused the trauma. The last, based upon the evidence of the police report, was that she was strangled by a tie around her neck. Unfortunately, there was no muscle or no neck as a result of the decomposition of being in the water. The doctor indicated independently, based upon his evaluation, his ruling out causes, came to the conclusion to a medical degree of certainty that death by history indicated, based upon the police reports, supplemented by his own medical examination of the body, that she died by strangulation. Why isn't that sufficient?
Well, and bear with me, Your Honor, in all deference to the court, I want to just correct on the facts. With regard to whether or not an injury occurred from the fall from the bridge or being thrown from the bridge, that would all depend on, and the testimony was such that it would all depend on how deep the Susquehanna River was. Because you would have to hit rocks or something hard to break bones. So it could have been drowning.
Listen, I'm not debating the facts.
Oh, no.
The issue here is the testimony of the doctor, whether it's admissible to the question. So taking that into consideration, the question is, why is that information not sufficient for this court to say, yes, that is appropriate medical evidence and the expert testimony such that it should come in? That's the question.
the opinion itself should not come in. Is that, I guess, what you're asking?
Yes.
Yes. Well, first I would point out that, number one, Dr. Ross did not engage in a complete examination of the body. Okay, now I'm not saying that all head traumas require a skull fracture, but I could speak from my own personal experience of having suffered many head injuries from playing sports and whatnot. In fact, I've had hematomas and I have scar tissue on my brain, and I've never fractured my skull. Okay, so Dr. Ross couldn't say, well, I looked at the skull and I looked at it with only my eyes and I detected. He did not take one x-ray to determine if there were other fractures. He then testified that, well, the brain and the dura were so liquefied and so necrotic that I couldn't even take a sample. Therefore, I couldn't see if there was any bleeding inside the brain. So to rule out trauma to the head when there is no medical objective evidence and the scientist or the pathologist has not carried out all testing that would be normally required in an autopsy.
My concern, oh, excuse me.
Could I follow up briefly on that? So the issue here seems to me, to at least part of it, seems to me to implicate the meaning of 703 in this context. So certainly forensic pathologists would, I happen to know one, it would certainly on a regular basis talk to, say, homicide detectives who would help to inform the context of their work and their investigation. And presumably, I don't know if you'll agree, presumably in testifying on a proper foundation, that kind of history could be developed in direct examination by way of what helped to inform the pathologist's opinion. I suppose that is, in your view, different from saying, doctor, assume with me that a witness will testify or has testified that X, Y, and Z happened. Now, does that change your opinion? So those are two different scenarios, I think, that you want us to differentiate in this case, or am I missing the boat?
I think I might have missed the boat on the question in its specificity, Your Honor. And that's on me with regard to that. I'm not saying that a pathologist taking into account history could not be used by the pathologist, but like, for example, in our case, he could have spoken to the detectives, and if they said head trauma, we spoke with Miss Bell, she said head trauma, hammer, okay, because they looked for forensic evidence in the bathroom and found very little, not to the extent that Miss Bell claimed existed. That would beg then the question, the competent pathologist saying, okay, you know what, they told me head trauma, they told me hammer, I'm going to x-ray the skull to look for this. So it would be relevant for the pathologist to develop his investigation of what's important here, the body. And he fell short on that. I understand why he didn't do toxicology reports, because the body was so necrotic and destroyed that he couldn't, the results would be unintelligible, not helpful.
Counsel, doesn't, as to the head trauma, doesn't what you describe here go to the weight of the evidence?
No, I don't think so, Your Honor, because it's going to an opinion.
Well, but he did some investigation, medical investigation, and based a conclusion on it. You're saying he didn't do enough. He should have done x-rays, he should have done, whatever else was necessary to look deeper into the head injury.
I'm saying it doesn't go to the weight of the evidence, Your Honor, because he didn't do anything that the jury sitting by itself and hearing Ms. Bell's testimony couldn't do.
Here's my concern, not with respect to what he ruled out, but with what he ruled in by bringing strangulation as a cause into his medical opinion, having already acknowledged that the death was undetermined based on the state of the body. He had to use the testimony and information not medically related from a witness to determine that. And my concern is that that evidence from the other witness may or may not have been properly admitted, may or may not be properly considered by a jury, but it shouldn't be coming from the medical doctor pathologist. It shouldn't be coming from a forensic pathologist who otherwise has admitted that, or has not admitted, has acknowledged that based on the state of the body, the cause of death was undetermined. So that's where I'm having a problem, getting across that a barrier of where his opinion should have stopped.
And, Your Honor, that's why I asked for a balanced application of Rule 702 and 7.
Have I just made your argument? I think I have.
Yes, I would thank you.
Why-
And the reason I would thank
Let him
you
answer.
is knowing your dissenting opinion in McConaughey, which I also cited to when we get to the particular issue of credibility and the impact that the expression of opinion might have.
Why aren't you talking about the issue that the Chief Justice just articulated?
About
The fact that his testimony as to the strangulation was such that he said without a history,
Yes.
the cause of death would be undetermined. Isn't that your point?
That
It's
is
based exclusively on history, and that's why, your discussion of the insufficient medical investigation of the head trauma is interesting to me, but it seems to me to be tangential to what precisely is the problem here, which is, in your opinion, bolstering the testimony of a lay witness regarding how the death happened.
Well, and ironically, I hate to say I take notes, and if I had gone through my notes entirely, that's how I was concluding with it after I went through.
We diverted you with our question.
No, that's fine, Judge. I like the questions. I like questions better than actually just reading from my notes.
I have a question.
I'm sorry?
I said, oh, good, I have a question.
Okay,
Did you have more to that?
I think I didn't finish, though, Justice.
Come back here when
Donahue.
you're done.
Okay, yes. Yes, exactly my point. When you look at the State v. Taylor case that I cited too, okay, which did a great explanation and actually did an evaluation of cases from across the country and chose a balanced approach, a case-by-case approach. What they said, which was very similar to here in the sense, except for the fact that in that case, the defendant appellant had made an admission to causing the death of the child. The Ohio Supreme Court viewed it from the standpoint where their rules of evidence are very similar to ours, said, okay, he had no objective findings that you could say he could reasonably conclude upon and that would fall within, say, the definition of specialized knowledge or scientific evaluation. So he didn't do, the expert, the pathologist, did nothing that the jury couldn't have done. I hope I answered your question. If I didn't, please.
That's what I understood the issue to be, so yes.
But it's a snowball, Your Honor, because once you get that opinion in saying strangulation by history, and I said it in my brief, it's credibility by association. And so when the pathologist said strangulation by history, bam, the jury went, well, if the expert believes him, cloaked in all of his expertise, his doctor, his CV, and he's saying he believes her. So
Let's
we
hear
better.
from Justice Mundy.
Well, my question is that it appears that your presentation here is, the strength of your argument is premised on the fact that the forensic pathologist didn't perform his duties the way he should have. And in the medical field, as I understand, the doctors are required to perform their duties to a requisite standard of care. And that's the rules for the medical field to apply to each profession so that they do their jobs the way they're supposed to do. And while I can appreciate your criticism of the pathologist, I don't know of any evidence in this record, unless you can shed your light on some, where there's somebody with the background, i.e. another expert pathologist who came in to testify to say that it's beneath the standard of care for a doctor to use history in formulating their diagnosis or their findings. And while you can argue about it, my understanding is that there was no expert presented here to say what Dr. Ross did was inappropriate. And for all I know, it's really part and parcel of what doctors do in coming to a diagnosis or ruling out causes of death is by utilizing a history.
Yes, Your Honor, a history that's normally given by a live victim, like in the McConaughey case.
But do you have any expert testimony that says what Dr. Ross did in this case was improper, it was beneath the standard of care, because forensic pathologists are not supposed to rely on information gathered at the crime scene by investigators and provided to them in performing their job duties?
I didn't try the case, and I would have probably called my own pathologist, but I don't think it was necessary in this case because of the testimony of Dr. Ross. Dr. Ross came out and explicitly stated that, look, I didn't take x-rays, okay? And by the way, even though I'm ruling out the head trauma, I can't say it didn't happen. He said that. So I'm not saying he didn't go beyond his standard of care. I'm saying that the process, if you're evaluating it, okay, well, I am criticizing it, yes, okay? But what I'm saying is he didn't take all the steps. Now, that happens all the time with physicians. They don't always take the proper steps or go to the farthest.
But in order to put that issue in front of a jury, in my view, I think you were obligated, or whoever tried this case was obligated, to provide the jury with what the standard is so that they can make a determination whether or not Dr. Ross did his job properly. That's where I am.
Yeah, and my position would be, even if he had done his job properly, which he didn't, I wish he took the x-rays, my position would still be the same, that he would likely have ended up with insufficient scientific evidence to base his conclusion on. And there,
an expert could come into the courtroom and testify, it is the standard of care for a forensic pathologist to accumulate any evidence or information they can with regard to the cause of death of that corpse. Doctor, does that include interviewing the police officers who found her and witness statements? That's what I'm saying.
Counsel, let me follow that up, if you may. The trial court accepted the testimony as an expert witness.
yes, Your Honor.
You're challenging the trial court's decision or the Superior Court's affirmation of the trial court's decision as an abuse of discretion or an error, legal error.
Yes.
Tell me what this is, since the record shows no contradiction. There is an expert testimony that was applied to a factual scenario. It was admitted. That's what the record holds. You're sharing with us an argument. We're not here to relitigate the case. We're here to determine, did the trial court abuse its discretion or did it make an error of law? Tell me, which did they do and how did they do that?
I would have to say an abuse of discretion, because we don't have an error of law in the sense that this court has not ruled upon this particular issue such that I could say abuse as opposed to error.
How is it abuse of discretion for the court to allow an expert testimony to come in based upon the other evidence and come to the beyond a reasonable doubt that your client's guilty?
Let me retract my concession with regard to the error of law. When I look at Rule 702 and 703, I look for medical evidence, okay? And in this case, there were no scientific findings by the pathologist to rule out anything or to rule anything in.
But there was not a challenge to that, as Justice Donahue said. There's no challenge to this history by death.
But both the Superior Court and the trial.
Or the death by history.
Yeah.
Death by history.
Yeah,
I apologize.
Strangulation specifically by
Strangulation specifically.
Yes. And what I'm saying is both the trial court as well as then the Superior Court ruled that, well, he did an autopsy and he based it on his own scientific knowledge coming to his conclusion, therefore it's admissible.
here's the problem I have. If the witness we were talking about was not a physician and somehow his opinion was relevant, that's one thing. But this is a physician. A forensic pathologist is a physician, and he is required to, and in fact did state that his opinions were rendered to a reasonable degree of medical certainty. How is strangulation by history, meaning by what other people told me or what other people testified to, how is that? And I don't have the relationships with forensic pathologists that some on our bench do, but how on earth is that testimony to a reasonable degree of medical certainty?
I argued that in my brief, Your Honor, and that.
Once again, I seem to be making.
No.
You need to stop talking about X-rays.
I'm sorry.
You need to stop talking about X-rays. Your case is very simple.
Yes.
Is that the trial court erred in admitting this evidence as expert testimony? That's your argument.
Yes.
And my question is, if Dr. Ross had testified, I can't exclude strangulation as a cause of death versus what he did testify, which is it is strangulation by history. We wouldn't be here, would we?
Not likely.
Because
only because
he did do an examination of the body. He did do what pathologists do. He did consider history, which is, you're not saying he can't consider history.
Exactly.
But your problem is he didn't say, based on the decomposition of the body and things like that, I can't exclude Miss Bell's theory or Miss Bell's testimony that it was strangulation. That would be a different medically based opinion that we wouldn't be here talking about. He said it's strangulation by history. That's what it is.
Yes, Your Honor, and that goes exactly to the head trauma. It's almost synonymous. He ruled out head.
Stay away from the head trauma, dude. Stay away.
And the other problem that I wanted to ask you about was his testimony that he couldn't determine the cause of death from a medical perspective, but he is nonetheless concluding to a reasonable degree of medical certainty that it was death by strangulation by history. That in itself bolstered, in my view, and I'm asking you, did it bolster the testimony of a fact witness who said it was a strangulation case based on what happened before the death? We have never, to my knowledge, allowed a forensic pathologist's testimony to bolster the testimony of a fact witness. So if you could elaborate on that, I'd appreciate it.
I think it did, Your Honor, because by stating, look, that day several days in the courtroom, there was only one witness who
that
could
was
say,
the history.
Yeah,
Right?
they could say what happened, and that was Miss Bell. And Miss Bell, as the story developed, it got worse and worse. Okay, it happened this way, then it happened this way, and then I did this, and then Mr. Walters did, and she didn't see this. She said, Mr. Walters told me this. Okay, so it was even further, further removed. Okay, and then Dr. Ross comes in after Dr. Riviello, who rightfully so the Commonwealth could have brought in to do exactly what Justice Brobson was speaking of. Okay, there were signs of nausea in the victim, so potentially strangulation. That's consistent with strangulation. Okay, which Dr. Ross did not do. Dr. Ross jumped way over that and went right to saying, you know what, I have no forensic evidence to support this, but strangulation by history.
Well, can I follow up on that? He testified that there was, quote, complete skeletonization of the head and neck organs, unquote.
Yes.
There's no hyoid bone. There's no possible way for a forensic pathologist to testify to strangulation. So coming back to, it's clearly, we've gotten far afield. This is a case that is on the theme of vouching, which we addressed in McConaughey.
Correct.
And there, in an opinion by Chief Justice Saylor, the majority stated, we hold that an expert witness may not express an opinion that a particular complainant was a victim of sexual assault based upon witness accounts couched as a history, at least in the absence of physical evidence of abuse. So this is a strangulation allegation, not a sex assault allegation. And it's a strangulation physical evidence issue, not a physical evidence of abuse. But isn't your whole argument that this is just like McConaughey? There's vouching. We said it was impermissible in McConaughey, and therefore it's impermissible here. Isn't that your argument?
Yes, and may I use the word more egregious than McConaughey? Because in McConaughey, the Dr. Novinger, I believe his name was, actually interviewed the victim. In this case, that doesn't exist. There was not a victim to interview. He was going on a witness from the Commonwealth to reach his conclusion where he had no objective evidence. And I would like to remind the court, and I know I'm going back, Justice Brobson, about this, but I just wanted to mention about the strangulation.
You do it at your own peril.
Okay. Thank you, Your Honor.
Which I mentioned
Thank you.
earlier, but
Yeah, no, I'm just saying, though, it wasn't just that the hyoid bone was missing and the cartilage was missing, but all the skin on the face where you would look for petechial hemorrhaging was missing. The
You
eyes
look
were
at the
gone.
eyes for petechial
Yeah, and there
were no eyes.
There was no eyes, so you couldn't look for petechial hemorrhaging in the conjunctiva. I hope I pronounced that right. Yes, and well, when I was reading Tyler, when I had to say the alveolar, which is or whatever it is in your lungs, I couldn't pronounce it correctly. But yes, it goes exactly to that. It's more egregious than McConaughey. And I wish you had participated in McConaughey so I could rightfully say, okay, Justice Weck, this is exactly what you found, but you did not. But Justice Donahue did join the majority in that case and found exactly that we cannot allow this. And I'm saying it's more egregious. And back in your dissent, Your Honor, you said, my fear with the majority's decision that this won't let other opinions in, but you didn't cite to a case similar to ours, where we have a dead body who is not interviewed as a patient, where a doctor could render a medical diagnosis. You mentioned patients giving their history. And I would say, yes, if this was a patient giving the history, then yes, in that case, if it leads to a diagnosis, then the history is admissible. But that's not what happened here.
Okay, I think we understand this part of the argument. I'd like to move on to the harmless error question, but before I do that, are there any other questions on this? All right, could you address the Commonwealth's allegation that even if we find that admission of the pathologist's testimony was in error, that such error was harmless?
Factually, Your Honor?
Anyway.
Okay. Yes, ironically, I submitted again a reply brief addressing that harmless error. And as the Commonwealth presented their argument on harmless error, they didn't do it from a factual perspective. Essentially, what the Commonwealth said in their principal brief was that, well, Dr. Ross's opinion was admissible, and therefore, and also that this would have been admissible as strangulation by history, therefore there is no harmless error. With regard to the facts of the case, Your Honor, it's a circumstantial case where Mr. Walters made no admissions to anyone other than allegedly Miss Bell that he had committed this crime.
Well, I think that what we're looking at is the other evidence presented at trial. Was it so overwhelming that the Commonwealth can claim that even if the admission of the pathologist's testimony was in error, that such an error would have been harmless given the other evidence presented at trial?
I could answer that shortly in a summary way rather than just reviewing all of the evidence starting from the very beginning. I don't believe the Commonwealth would have had to have even used a pathologist in this case to come to the conclusion of strangulation by history if their case was so strong.
But the fact that they did, you could infer that the jury would be impressed by a medical doctor's testimony, perhaps more so than a lay witness?
Yes, Your Honor. And I think that unintentionally, or maybe it was part of their strategy, was to utilize Dr. Ross to make the sole witness more credible in the eyes of the jury, okay? Because she didn't, her story grew slightly inconsistent, and she had motive to lie because she wanted a relationship with Mr. Walters, and Mr. Walters said, I'm going to break up with her, but then, or with Miss Lorenz, but then he didn't, and then he continued to engage in dalliances with Miss Bell. So she had a motive to lie about what occurred here. So she wasn't a straight-off credible witness. And so, and the forensic evidence that was developed was semi-unremarkable from inside the house, in all candor to the court. And I'm saying this as it's being televised, but there was a sexual aspect to this with regard to Miss Bell and Mr. Walters that involved BD.
We don't need to hear that.
Yeah, but I'm just.
We don't need to hear that. But what I was getting at was, can you respond directly to the Commonwealth's claim that even if the admission of the pathologist's testimony as to strangulation by history was in error, that error was harmless given the other evidence in the case? Can you just, from a legal perspective, maybe?
Yeah, sure. It would just come down straight to the fact that if you looked at the evidence, well, I guess what the court has to say is, if can we say that if we took this out, the Commonwealth would have still proven their case beyond a reasonable doubt? And in this case, at least my view, because I'm the defense. So, I mean, for what it's worth, Your Honor.
It's worth a lot.
Yeah. All you have is the testimony of Miss Bell, okay? No forensic evidence that shows that there was indeed a murder committed by Mr. Walters other than being associated and living with Miss Lorenzen. In fact, they did an examination of her car, not her car, not Miss Lorenz, Miss Bell's car, and Mr. Walters' car, the car that was allegedly used to transport the body, and found no forensic evidence in the car. In fact, the car was filthy, such that it hadn't been cleaned. So if a body had been placed in it, the body would have...
So your argument is that the testimony of the doctor only bolstered the credibility of a co-defendant witness, for which was pretty much the sole source of information provided for this conviction. Is that your position?
Correct.
Okay, thank you.
Key and central, because the evidence, how shall I put it? The forensic...
You just shared with us. It's really going to be the Commonwealth that has to tell us why. You've made your point over and over again, and I think this court really, truly understands as I just articulated it. The question is, now let the Commonwealth get up here, but feel free to continue.
If you need
if you feel compelled.
Please do so, but I believe our questions have been answered.
Yeah, let me just, could I have a second to look at my notes? I wish my wife were here, Your Honor, because she always grabs me to stop me from talking more.
Should be here.
So, okay. Well, Your Honor.
We could ask somebody to come up. If it...
Thank you, Your Honor. So,
Take your time. That's fine.
We might need a forensic pathologist to come in to examine your...
Examine me. Yes. Thank you, Your Honor. None. I'm done, Your Honor. Thank you very much for being patient with me.
Thank you, Counsel.
Good morning. May it please the court, my name is Deborah Albert Heiss. I'm the first assistant district attorney in Wyoming County. I proudly represent the Commonwealth. I will say I was second chair and sat through this trial for the Commonwealth, so I have a very good grasp of the facts. I was the one that presented the direct of Ms. Bell. I believe that Justice Mundy and Justice Dougherty hit the nail on the head when they talked about what it is that this court needs to review, and I see this issue as a greater issue than just this one specific case. Specifically, I think the question is, who gets to decide what it means for an expert pathologist to render an opinion to a reasonable degree of medical certainty?
I think we do.
We do. That's an easy one.
Then that is going to be new, I think. In the past, That is not what has been the case. Quite frankly, if you look at all of the cases that have come down from this court and the Superior Court, that is a medical determination that the trial courts have been making, deferring to the medical community. I cited in the brief.
Well, how is it medical in any way, forget this case, any case, for a medical professional who says he or she can't render an opinion to a reasonable degree of medical certainty, and then be told what a lay witness said and then change his or her opinion? How is that medical in any sense?
Well, I'm not a pathologist, so I can't speak to that, and that's, I think, the crux of the issue. So in the case of State versus Commander, which is, I understand, a South Carolina case that I talked about in my brief, that particular expert stated that not only should they consider history, but they must consider history.
I agree that history, I think we all know what history is. The
Yes.
question is this vouching that we said is not okay in McConaughey? That's the issue. It's like a Rule 703 issue,
Yes.
because we understand history, but isn't this more like the vouching we did not permit in McConaughey? How is it different from that?
I was just going to say, coupled by that, share us how the Commonwealth distinguishes this case from McConaughey with regarding the bolstering of the credibility of an independent witness.
Well, in this particular case, there were several points where the pathologist disagreed with the lay witness. Specifically, the pathologist indicated in their testimony that there was no evidence of any head trauma, even though the lay witness testified that there was a hammer to the head. He had no findings of that. He also testified that there was no medical evidence of any type of injury resulting from a fall from the bridge, which the lay witness said.
No medical evidence of strangulation either.
Which is the big question. How is it not an abuse of discretion for a judge to allow? So what we have here is a doctor who said, you know what, Miss Bell, co-defendant, participant in the disposal of this body, shared with us, and we know the facts. So falling from the bridge, no, he ruled out trauma to the side. Beating by a hammer, no, we ruled out beating by the hammer based upon a visual of the skull. Oh, it's history by strangulation, despite the fact that there's no throat or no Adam's apple left, because it doesn't exist, like the lack of trauma. So what makes the trial judge share with us how that evidence just doesn't bolster the testimony of the co-defendant / participant of the murder, Miss Bell? I'm really struggling with your argument.
So the strangulation was the one possible cause of death that he could not rule out.
Right. And if he had said that, we wouldn't be here.
Well, there are all kind of possibilities, but here he was Ross candidly said, there's no neck. I can't tell you this was right. So then he's presented, I guess you were the one, right? That a witness that was not present at the murder, Bell, and that Walters claims was compromised with the motive or whatever, had told investigators that Lorenzen had been strangled by Walters, and based on that, he changed his opinion. How is that not the vouching we said you can't do in McConaughey? I'm failing to see the distinction from McConaughey. I know I'm asking it again.
I understand. That's all right. First of all, I think that when the pathologist considered he didn't only consider history. He considered other factors as well. I mean, the fact that this body was pulled out of a river clearly indicates it was not natural causes.
But we're not talking about what he ruled out. We're talking about his opinion to a reasonable degree of medical certainty that it was the cause of death was strangulation by history.
Because it
That's
changed.
really the cabin.
Yeah, because it changed. He said it's undetermined, and then he said, by the way, Bell said X, and therefore they said, oh, in that case, I mean, nobody's accusing him of dishonesty or violating a professional standard. It's what we're probing is Rule 703 and how this is not vouching. That's the question, not anyway.
I understand your question.
It's a legal question for us, not any attack on the expert.
No, I understand, and I'll be happy to try to answer that question. But it seems as if when a medical examiner tries to determine a cause of death, they look at the physical body first, right? And then, of course, they're going to get some history, but I think the history guides them in some regard in what direction they're going to go. I mean, they're obviously not going to consider, well, did this woman die during childbirth, for example? That's obviously not even something they're going to try to consider, because it's clearly not, from the facts of the case, something that is even a consideration. So I think that the history at least points them in the right direction. So in this particular case, I think that Dr. Ross clearly knew that this woman did not die of natural causes. Okay, so he knew right out the gate from facts and history that this was not, we're not talking about natural causes. So he starts looking at other than natural causes. What possible other than natural causes could there be? Perhaps she was hit with a hammer over the head. Well, he ruled that out. Perhaps she died of a fall from the bridge. Well, he ruled that out. The only other thing is the strangulation.
But how can you say that? That's speculation. Without getting into the gory details or the salacious details, we know that the woman had participated in some rough action. How do we know that she wasn't suffocated or had a massive heart attack? There's no indication of that either.
Right. Well, I know that the body was severely decomposed, but the doctor did say that the torso was preserved enough that he could check some of the organs, and he didn't see anything in any of the organs that would have indicated.
What does that have to do with
That led him to
strangulation?
conclude then that the cause of death, the medical cause of death, was undetermined.
See, this goes back to my, first of all, I'm struggling with the idea that the lack of evidence can rule out a cause of death, but the lack of evidence can also rule in a cause of death. I'm struggling with that, number one. And number two, I really just think you asked the expert the wrong question. If you would have asked the expert, can you rule out strangulation? And the expert would have said, to a reasonable degree of medical certainty based on the condition of the body, I cannot rule out strangulation as a cause of death. That would be fine. But, you're like the Phillies going for a grand slam here. You asked the grand slam question, strangulation. The expert said, yes, it was strangulation. And that's where I think it crossed the line. I think you're going into McConaughey. I don't think anybody up here is suggesting a pathologist can't consider, let alone shouldn't consider, medical history or history in general or the theory of the case advanced by the prosecution. No one is saying that. The problem is here, that's all there was. That's all there was. And you don't want to grapple with McConaughey.
So if I can respond to that, my co-counsel, who was the district attorney at the time, Mr. Mitchell, actually presented the evidence in the form of the testimony of Dr. Ross. And I know that it was important to introduce the death certificate. And in order to introduce the death certificate, it's kind of, the checklist. You have to go through all the things you have to ask of the expert, one of which is, what is the cause of death? And the expert did testify that undetermined is put on every single patient when they first start the autopsy, every single one.
But this ended with undetermined.
He ended it with strangulation by history. So I don't know that there's enough evidence to say that he only relied on the information provided by Gable Bell. He relied on other information. There were cell phone records, there were texts, there were Snapchat records.
Okay, could I just clarify this? I have Dr. Ross's testimony here, and he says the conclusion as to my cause of death was that she died by strangulation, which was by history. There was no anatomic indication that she was actually strangled. If I would have looked at the body alone without any history, I could not say that. It would have to be an undetermined death. That's not the same as saying, well, we always put undetermined death until we do further study.
I agree with you.
So with that in mind, share with us why this court should not believe that that statement bolstered the testimony of co-defendant Bell.
The reason that I don't think that it bolstered her testimony is because the medical examiner specifically contradicted her on 3 separate occasions.
But the question, that's really, I don't see how that's germane. The issue here is, given that he frankly testified as he had to, because there's no neck tissue, that it was undetermined, right? So then how is saying Bell said X, therefore, doctor, what say you? How is that any different from if I called you as the the expert and I said, counsel, you've said it's undetermined, but this gentleman here said X, and therefore, and then you say whatever he said. And what I'm trying, isn't this just parroting, which we could have used? It didn't have to be Dr. Ross. Any witness could be told, assume X, and then just parrot back to us X, because it doesn't require any medical expertise at all to simply parrot back what you've been told a witness has told investigators. Does that make sense?
Yes, it does.
So
And
how is that not a problem for you here?
So in spite of the testimony that Chief Justice Todd just read regarding the testimony of the medical examiner, I do believe that the independent history was taken in conjunction with the physical evidence that he observed in coming to his conclusion. Now, I understand that he didn't have any physical evidence of strangulation, but it is obvious through his testimony that he considered a large range of things, all the things that he was supposed to consider based on best practices in his profession.
There's no doubt about that, but he ruled I'm not even sure he ruled them out. He said, I can't say whether they happened or they didn't happen. I'm not sure that's the same as ruling out. He said, I can't do, it was basically skeletal remains. There's a lot of things I can't determine. I can't determine a lot of things. And then you say, well, then by him not being able to determine a lot of things, he ruled them out. See, I think if there were forensic evidence to specifically rule out other theories of death, blunt force trauma to the head, blunt force trauma to interior organs, drugs, and he ruled out like a litany of a whole bunch of possible deaths, and all he's left with is this other theory, strangulation. Then again, I think it might be a different case. I'm not sure it is a different case, but it might be a different case. But here, he couldn't rule out things and he couldn't rule in things, and I mean, that's again the problem. At least I see that as the problem. And again, the Commonwealth seems to want to have this idea that the absence of evidence can rule things out and the absence of evidence can rule things in.
So I would just note that the jury heard all of this. So the jury
over the objection of the over the objection of the defense.
It seems like the only objectionable statement was the actual cause of death. I mean, the rest of the statements, which are, in my mind, almost more important than the actual cause of death.
How can you come here on this appeal and say that there's something more important than Dr. Ross's testimony, that the cause of death was strangulation and the manner was homicide? I mean, that's why we're here.
No,
I mean, because you're going into other areas. I mean, maybe I could ask you this. Assuming for a moment that his testimony was inadmissible, what overwhelming, uncontradicted evidence was there that proved how this victim died?
So there were, in addition to the statements of Ms. Bell, which obviously was the primary evidence, there were text messages, Snapchat messages, there were cell phone records, there were inconsistencies.
Regarding strangulation?
Yes.
Yes?
Yes. So
I thought the snapshot was about the chat and all of those other media evidence stopped before there was any recorded history of the strangulation.
that's true. However, there was role-playing about how she would be killed if they
Did that
were.
include strangulation?
Yes, and also throwing her in the river. Yes, it played out exactly. It played out exactly as they role-played it. Exactly, except according to Ms. Bell, Mr. Walters committed the homicide.
It sounds like you could have perhaps won the case without the pathologist's testimony.
I believe we could have. However, I think that everything that my understanding of the issue here is that the only thing that he said that the defense questions is the cause of death.
Here's the problem. If you have two fact witnesses saying the same thing and one fact witness's testimony was admitted in error, maybe that could be harmless error. But when one of the witnesses is a professional, a medical doctor, a forensic pathologist who is called as an expert, that elevates his testimony before a jury above that of a fact witness. So for us to conclude that if this was erroneously admitted, it was not, that it was harmless, That's a leap for me, so perhaps you could help me get there.
Yeah, so I will note that the jury was given a jury instruction about expert testimony and how they are to consider it, and that experts are to be treated just as lay witnesses in terms of credibility. So the jury was made aware that just because this person says this doesn't mean you have to accept it as true.
Well, that's clearly true, but we need to, if we determine it was inadmissible, we need to determine whether it was harmless beyond a reasonable doubt. So how is it harmless, in that scenario, how is it harmless beyond a reasonable doubt?
So let me start with the three standards for harmless error. I'll go in order. First, it was not prejudicial or it was de minimis. In this particular situation, I don't know how the jury could listen to Dr. Ross's testimony and think anything other than he doesn't really know. Okay, so because he said so. He said so. I mean, he was honest. He said, "I don't know. I'm coming to this conclusion based on history." He said.
But he stated a conclusion.
He did say that.
Reasonable degree of medical certainty.
He did say that.
That's
So
the issue.
and the jury heard him say that, and they know how he got there.
But the only basis for him to come to that conclusion is based upon Ms. Bell's testimony that the victim was strangled by a tie.
Right, and he said that. He said the history was Ms. Bell. He said the history was Ms. Bell.
But you can't unring his words. The conclusion as to my cause of death was that she died by strangulation, which was by history. That was his conclusion. He didn't say, maybe, I'm not sure. That was stated as his conclusion.
I understand.
That was his conclusion, and made within a reasonable degree of medical certainty, which elevates that testimony above any layperson within the jury's hearing.
Right, so I believe that because of the extremely compelling testimony of Ms. Bell, that this was merely a reiteration of what she already said.
Well, it was, her testimony was challenged and contradicted. I
Yes.
mean, so you could have a hunch, I suppose, that I guess you're telling us that in a scenario where Dr. Ross's opinion was excluded, ruled inadmissible, that you think a juror would have a hunch that he killed her, and assuming that, how can you tell us that is elevated beyond a reasonable doubt?
I think that it would be more than a hunch if they had already listened to Gable Bell's testimony, and which she preceded him in time in the trial, and listened to her extensive testimony about the way that the death occurred. It seems like that would have been cumulative.
Well, but it has.
They had to have believed her.
Yes.
That's the whole point of the vouching problem we have here.
Well,
You're right, they could have believed her or not. I mean, it was totally a matter of credibility, and so when a medical expert takes the stand and vouches for what she has said, it changes the entire complexion of the trial and her testimony.
Well, I understand that she was a lay witness, and obviously there's credibility issues there, but every single thing she said was verified, and the defense had an opportunity to cross-examine her, and even though they alleged that her statements were inconsistent, they really weren't.
Commonwealth, share with me, did they recover the tie that allegedly strangled her? The answer is no.
No, I don't think so.
So when you just said they verified everything she said, that's not true. It's not true.
Well,
all we have is a body that's so decomposed, and the doctor's comment was the only thing missing from that body were her feet and her hands, because they were still attached to the bags of rocks.
Yes. That's
Okay, I think we get it. If you want to sum up on either of your arguments, you may do so.
Thank you. I just want to also touch upon the point that Justice Mundy made, is that there was no other defense expert presented, and I think that might have shed some light. I also feel like this doctor was faced with giving an answer to a question that he had to give to a reasonable degree of medical certainty based on the standards in the industry at the time, which were that it was okay to come to a conclusion based on history. That was the standard in the industry. It was okay to come to a conclusion based on history. So in the absence of any physical findings, it would have been acceptable to use history to help him reach a conclusion, and I feel like that's what he did based on the standards in the industry. So that's why when I started my argument in terms of who decides what it means to be to a reasonable degree of medical certainty, I think from the witness's perspective, his industry decides that. From our perspective, you all decide that. So there is, I think, a disconnect there.
We'll certainly take a look at that.
Thank you.
All right, thank you both. Mr. Minner, would you call the next case?
KEM Resources LP versus Ryvamat, representing Ryvamat, Mr. Thomas Elliott, representing KEM Resources, Mr. Burt Rubin.
You're outnumbered.
I don't think I am.
And used to being outnumbered, correct?
Yeah, probably outbilled.
What's that?
And you flourish.
Let's not get into that, Mr. Justice.
Yeah, how about that? All right, this case is an appeal by allowance, and we will address whether an action for an accounting of the proceeds from the sale of an oil and gas lease brought by co-owners of real property that was the subject of the lease and who were out of possession at the time the lease was made is subject to a 4 or 6 year statute of limitations. And I know this is an issue that the students are so anxious to find out the answer. Please proceed, sir.
Good morning. Chief Justice Todd, Associate Justices of the Supreme Court. My name is Tom Elliott from the firm of Elliott Greenleaf, and I appear today on behalf of Appellant Ryvamat. I appreciate the court's factual recitation. It will eliminate some of my presentation, which is its intended purpose. No. In any event, let me start with two things that I think are critical to the analysis here, and that is that both the Aplt groups here, who were the plaintiffs below, are composed of very sophisticated and long experienced people, especially in land ownership issues and especially in land ownership issues and transfers in the Endless Mountains region of Pennsylvania, beautiful section of Wyoming County adjacent to my paternal grandmother's home county of Bradford County. But in any event, and it's critical to know that since at least the 1950s, for the individuals I'll refer to as the Kemmerer Aplts, they've been active in this area, and at least since the 1970s. So, for the Endless Mountains hunting group, those important features will figure in later when we determine that they had a very simple claim to make. My client Ryvamat received the proceeds of the gas lease on the 21st of July of 2008. On the 4th of August of 2008, Ryvamat filed and recorded with the Recorder of Deeds the oil and gas lease that is at issue in this litigation. So it's clear from the outset that the Aplts missed the 7/21/2012 statute of limitations for what they pleaded as a breach of contract. And it's also clear that when they filed the complaint in July 18th of 2014, they were 3 days shy of 6 years from when Ryvamat got the proceeds of the sale. So they completely missed the proper statute of limitations deadline based on what they pleaded, and they nearly missed but for 3 days, they nearly missed the complaint that they bring in this action. It's clear that the competing interests here, that they joined forces for years. The Kemmerer Aplts and the Endless Mountain Aplts battled each other in court and probably elsewhere regarding the claim of rights to recover under the oil and gas lease. Rather than filing in a timely manner, they continued to battle even after they filed the initial complaint. And it wasn't until September 8th, 2015, when they filed the second amended complaint, that apparently peace broke out between those warring factions, and they came together to assert a claim as KEM. And that is about all I need to add on the facts. The critical thing in this case is that the lower court made a decision to dismiss the statute of limitation claims made by Ryvamat, despite the fact that, and relied on a statute that was never pleaded, never argued, and not argued, I don't mean just at the trial court level, I mean at any level. They claim that they argued this statute, 68 PS 101, at the trial court, but the record cites that they use, they play fast and loose with. I cite the 647B and 620B.
Counsel, can I interrupt for a moment?
Yeah, please.
Assume that they didn't raise it at the trial court level. The trial court found that a 6-year statute of limitations applied for reasons other than the Superior Court found the 6-year statute of limitation applies. Can't the Superior Court affirm for any reason as long as all of the facts essential to stating that statutory claim were in the complaint in this case?
Not, Your Honor, when there is another statute that is the more appropriate statute of limitations,
but
and that's
but isn't that a different question? I mean, if the Superior Court could have concluded within their purview of affirming for any reason that these plaintiffs asserted a statutory claim, would not the 6-year statute of limitations apply to that statutory claim?
if they had asserted a statutory claim.
And why do you say they did not?
It's nowhere in the, if you look at the complaint, the amended complaint, and the second amended complaint, there's no mention of the.
Let me, in the vernacular, say, so what? If they pled all of the facts necessary to establish the elements necessary for a statutory claim, why could not the Superior Court conclude that they stated a statutory claim, whether or not it was pleaded or not?
Well, I think the critical focus of that, Justice Donoghue, is that the option of the Aplts that they ignored, which would have brought it within the proper statute of limitations, was totally driven by them. It's not. I don't think it's the court's responsibility to make the facts fit a claim.
Clearly not a court's responsibility, but isn't it the intermediate appellate court's within its purview to do precisely what they did here? Affirm for another reason, based upon facts pleaded and the record.
I think that's so, if it's consistent with what the facts are that are stated in the record.
And you're saying they are not.
And they are not. And I think that the critical point there is that that the appellees specifically rejected. Not only did they not plead, not argue the statute on which the appellate court, the lower court, made its decision. They, in fact, rejected it and said, no, that's not what we want. So I still don't think it's the role, as you said, of the appellate court to find a outcome that suits an unpleaded, unargued claim. I think that important to note, and the only other 2 points that I'd make, is that especially where the conduct of the appellees is the only reason that there's even any dispute here. That's the only reason that there's any case here. They simply ignored their responsibilities to act within the parameters of the laws of Pennsylvania. And one need only look at the complaint to see how far they missed it, or what the margin was that they missed it. I think that
Mr. Elliott, could I interrupt for
yes, please.
I'm sensitive to the idea that if there's a statutory cause of action, it's important to at least identify it, but only in certain circumstances. And the circumstances I'm thinking of are where the statute itself creates affirmative defenses, or there's elements to the statute, there's actual elements of the statute that have to be pled. You could raise a PO of something like that. Was there anything about this statute that you are claiming, if they wanted to plead it, they had to plead certain elements that they didn't, and if they had pled it the way you wanted them to plead it, you would have been able to raise certain defenses that you didn't, because you didn't know that they were pleading the statutory cause of action? If
I'm correct, Justice Robson, I think you're getting at the notion of where's the damage? Where was I? How was my client? No, I missed that. Then. I'm sorry.
No, it's okay. There are statutory causes of action.
Yes.
There are elements that the General Assembly says that you have to plead for a statutory cause of action, and sometimes the General Assembly will give you defenses in the statute. I'm asking you, is that the situation here? Were there particular elements that they were required to plead that if you had known they were pleading the statute, you would have raised a different objection? Is there an affirmative defense or a statutory defense available to you that if they would have identified the statute in the pleading, you would have raised, but you didn't? I'm not really asking a prejudice question. I'm really asking, is this a situation where it is absolutely critical that they identify the statute in the pleading? That's what I'm asking.
I think it's critical in this sense, and that is that that statute contains no statute of limitations. So where do you look for a statute of limitations confronted with its situation? And the answer is you look to the most reasonable source of a statute of limitations to control the matter, and that's 5525-4. It's which is this court well knows that in 1979 or 78, the General Assembly put a new statute of limitations in place, especially for and directed towards, one of the aspects to which they directed it was the contracts, implied or stated. And 5525-4 says that an action upon a contract implied in law. That's exactly where the lower court missed the ball, did not even consider that, and went on to rely on the statute which it did. I think that the additional comment that I'd make is that keeping in mind the thoughtful opinion authored by Justice Wecht in Bednarowitz. My apologies if I mispronounced the name.
You got Wecht right. That's the important.
Beg your pardon?
You got Wecht right. So.
Thank you very much. Is important because in that case, even though it went the other way and enforced a 6-year statute of limitations, it was in an effort to confine the claims there. It was an effort to keep them away from a 21-year no statute of limitation applied argument. And it's also important to note at the same time that that court, that opinion by Justice Wecht, then Judge Wecht on the Superior Court, relied upon the actual, or focused on anyhow, the dilatory conduct of the parties there, and the fact that the entire dispute could have probably been avoided and certainly wasn't going to be expanded. Here, the lower court created the statute of limitations which it applied, and did so wrongly. They never looked back to the pleadings themselves or to what the parties argued, and completely.
Can I ask you a question?
Beg your pardon? Yes.
Can I interrupt and ask you a question? I am understanding that your argument is that the trial court should have applied the 4-year statute of limitation attached to a contract action. But I'm curious what contract was there?
Well, the contract is between that's why it's an implied contract. The contract is between Ryvamat and Unit Petroleum.
But there's not a written contract that you're.
Well, the lease is. I'm sorry. It's the lease.
Well, that's what I thought you were going to say. And the appellees in this case weren't a party to that lease.
No, but they were susceptible to the impact of a contract implied in law, and that's the argument that I would present on that. I conclude only with the thoughtful footnote of Judge Olson in a case that not only is significant but thoughtful, is the Kervilla case, the Superior Court holding in Kervilla, and it addressed the statute of limitations in equitable accounting, and it cited the case, this court's opinion, the Supreme Court's opinion in Ebert, and cited it with this significant observation, and that is that the claim in this instance, was significant to that comment by Judge Olson, the footnote by Judge Olson, that what has to be applied, because it is still the law of the Supreme Court, has to be revisited on occasion to make sure that that law is still continues to be good law, and that is the reason why this court should revisit that that application of the statute of limitations and reverse the lower court and dismiss this action.
Thank you, Mr. Elliott. Let's hear from Mr. Rublin.
May it please the court, Bert Rublin on behalf of Appellee KEM Resources. I'm joined by my co-counsel on the brief, starting with Mr. John Minora, Mr. Dan Clement, and Mr. Emil Minora. They've been litigating this case far longer than I have, in fact, going back to 2008, when they were involved with the predecessor to Ryvamat, Deer Park, which had secured a default judgment against the predecessors of KEM. This is a claim for an accounting against a co-tenant by KEM for the $12.6 million in proceeds that Ryvamat received from an oil and gas lease with Unit Petroleum. There's a 6-year statute of limitations. The catch-all is 42 PS 5527B. That applies here regardless of whether this claim is a statutory claim under 68 PS 101, as found by the Superior Court, or a common law claim derived from the statute of Anne by one co-tenant against another co-tenant for income or rent derived from commonly held property as held by the Common Pleas Court. I think it's important to emphasize up front that neither this morning in Mr. Elliott's oral presentation nor in the two briefs that were filed by Ryvamat have they cited one case, not one, either with respect to the statutory claim or with respect to the Commonwealth, common law claim, that has applied a 4-year statute of limitations or a 2-year statute of limitations. On occasion in their briefs they suggest that this is a 2-year or a 4-year statute. But the salient point is they have not cited any case, whether before the 1978 amendments to the statute of limitations or thereafter, the 45 years thereafter, that has ever applied a 4 or 2-year statute of limitations. Quite to the contrary, the lower courts have consistently, uniformly applied a 6-year statute of limitations to all of these claims by co-tenants against another for rent or income derived from commonly held property.
Counsel, if you have a claim for an accounting, what are the elements of your cause of action? What do you have to prove?
Well, I think it's important, Your Honor, to focus on the nature of the accounting.
Well,
This is a unique species of accounting. This is an accounting that is not ancillary to relief. This is an accounting that is in itself a cause of action. It's a cause of action that's under 68-101, and we've spelled out the statute. And as Justice Robson pointed out, all the facts that are alleged in the complaint were sufficient to support the statute.
I pointed that out, but you've just conflated your argument. You said, and I quote, whether or not this is treated as a claim for an accounting or if it's treated as a statutory claim.
What I meant to suggest, Your Honor, was a claim for an accounting, and I was perhaps using shorthand, by a co-tenant or co-owner of property against the co-tenant for rent or income. And the common law claim is, as I said, derived from the statute of Anne, which is incorporated in Pennsylvania law by 1 Pennsylvania Consolidated 1503. What the elements are, and the facts were alleged in the complaint, the original complaint, the second amended complaint, which is the operative complaint, are you've got co-tenants, you've got a tenant that's out of possession, which is the case here during the pendency of the default judgment. You've got the tenant who's in possession, who derives income or rent while it's in possession, who then does not share that income or rent with its co-tenant. And to Justice Brobson's question earlier, the Ryvamat has never argued, either in its briefs or this morning, that the facts alleged in the complaint did not support a claim under 68 PS 101. They have not alleged that they are in any way prejudiced by the Superior Court's invocation of 68-101.
Right. I'm not sure you – I think Justice Donahue is correct in that you have conflated the common law, alleged common law cause of action for an accounting with the statutory It seems like no court really wants to wrestle with this question of whether there is a common law cause of action for accounting or an action in law for accounting or an action in equity for accounting because we have the statute. Why can't we just live with the statute and not wrestle with this idea that there's some sort of common law action that doesn't involve a fiduciary duty, that doesn't involve a contract, that doesn't involve what we know as causes of actions? Why do we just stick with the statute and call it a day?
We could do that, Your Honor, and I think we prevail if that's the analysis that this court wants to undertake. The Bednarowitz case that was authored by then Judge Wecht, joined by then Judge Donahue, is really on all fours with this case. That case did not involve the statute. There, the claim was pleaded as a matter of common law. And the reasoning in that case by Judge Wecht was the same reasoning that was employed by Judge Collins in this case with respect to the statute. And that is that 68101 does not itself prescribe a statute of limitations. There are no Pennsylvania statute of limitations that either refer to 68 PS 101 or refer more generally to a claim for an accounting by one co-tenant against the another.
See, you lost me a little bit there, because for statute of limitations to refer to a claim for accounting has to exist.
Right.
and that's it doesn't surprise me that the statutes don't refer to a claim for an accounting, because I'm not convinced there is one. I've always viewed accounting as a form of relief incidental to a fiduciary obligation of some sort, or a breach of contract or something like that. I go back to my point, because when you answered my question, you went back to the statute.
Well,
it seems to me that the statute is the answer here.
I will take a win any way I can get it.
Why are you so hesitant to take that win? Why are you arguing that you pleaded an accounting? I mean, that's what I'm struggling with here. I mean, it appears to me that the statute is exactly on point.
Oh, I agree. The statute is on point, and perhaps I'm swinging for the fences for that Phillies grand slam, because I do want to argue that the Common Pleas Court got it right. But I think it's important to make a couple of points. Number one, they've never cited any case that applies a 4-year statute of limitations. Number two, they have not argued that the Superior Court got it wrong when it held that there is a 6-year statute of limitations, that is, the catch-all applies to a statutory claim under 101, because of the fact that the statute itself does not prescribe a statute of limitations.
Well, I think they are arguing that. I think they're challenging that on two grounds. One, they're challenging it on the ground that they didn't plead it. So you shouldn't, in the face of a statutory cause of action, they're arguing that the law in Pennsylvania should be you must plead the statute versus plead the facts. That's the first argument. The second argument is your theory of the statute, your application of the statute in this case, is more sounding in a sumpsit as a contract action, and therefore it's more appropriate to apply the contract statute of limitations. So they are challenging it.
Well, two arguments there. Number one, they have not controverted the conclusion of the Superior Court that the facts as pled would support the statutory claim. As to the contract claim, Mr. Elliott made an assertion that my clients had pled a contract claim, which is not the case.
I think Mr. Elliott's assertion, to be fair, is that your claim sounds in contract, and the idea that he's presuming he wins on the idea that you had to plead the statute. Your pleading sounds more in contract than it sounds in some other kind of accounting stuff thing.
Yeah, and we obviously take issue with the notion that this claim sounds in contract. And I do want to hearken back that there are cases under the common law that hearken back to the Statute of Anne, which is incorporated in Pennsylvania law. The Bednarowitz case is a common law case. And so I think the common law can exist side by side with the statute. I do want to respond to the notion that the fact that it was not expressly pled in the complaint is somehow dispositive. This court addressed that exact question 100 years ago in the decision in Goldberg versus Friedrich. And that case said, where the facts relied upon bring the case within the statute, it's not necessary to plead it. And that case has been followed repeatedly for the past 100 years by the Superior Court, was followed by this court in Turner versus School District. They have not disputed that the facts as pled in the second amended complaint bring this accounting claim within the ambit of the statute. They have not challenged the fact that the facts as pleaded in the second amended complaint would indeed support a statutory claim.
And it's not clear to me, I mean, whether it's dispositive or not, but it seems odd to me that the statute wasn't pled.
They pled generally under Pennsylvania law, paragraphs 44 and 47. I do want to correct another misstatement that Mr. Elliott made, unfortunately. The statute was indeed raised earlier by my clients. I was not involved in the litigation, but we've given the record citations. It was raised in the summary judgment briefing in the trial court.
But it wasn't pled.
It was not expressly pled in the complaint, but as I said,
that may be inconsequential.
This
seems peculiar.
It's inconsequential because A, this court's precedents say you don't need to expressly plead the statute. B, we went under the common law anyway. I do want to address one other point that was made.
I don't think you want to say that.
Excuse me.
We went under the common law. I mean, if you're saying we went under the common law, then you're saying we didn't mean to plead the statute.
What we did was we pled Pennsylvania law generally, and
which includes common law and statute.
Correct.
That's a better way of phrasing it.
And that's what this court's precedents say. I do want to deal with the notion that my clients were dilatory and sat on their hands for an undue length of time. That argument by Ryvamat is completely contrary to the argument that their predecessor, Deer Park, made at the outset of this case. Recall that there was a default judgment in the quiet title action that was filed by Ryvamat's predecessor and close affiliate Deer Park. Believe it or not, that default judgment stood in place for over 6 years. The predecessors of REM filed prompt motions to vacate, and they understandably waited to file this accounting claim because at the time, by reason of the default judgment, the state of the law and state of the title was Deer Park, the predecessor to Ryvamat, had a 100% interest. So they were concerned that if they filed a lawsuit for an accounting to get their 50% share of the payment made under the oil and gas lease, they would be met with an argument, you've got no standing. And in fact, it's exactly what happened. They filed this lawsuit in July of 2014, within the 6-year statute of limitations, and they're met with a demur. And the demur, not surprisingly, by Deer Park, which is Ryvamat's predecessor, says, wait a minute, there's a default judgment that's still out there, hasn't been vacated. This lawsuit is premature. And I want to direct the court's attention for that to, bear with me, pages 18B and 19B of the supplemental reproduced record. Their demurrer said, until plaintiffs successfully obtain an order striking or vacating the default judgment in the quiet title action, they have, as a matter of law, no rights to or interest in the oil and gas on the subject property. Thus, all of the claims raised by plaintiffs in the present complaint are premature and legally insufficient. They are not tenants in common and are not entitled to an accounting with respect to the Ryvamat and Unit Petroleum lease. So my clients were in a damned if you do, damned if you don't position. They were waiting and waiting very patiently for the Common Pleas Court to act on their petition to vacate the default. For whatever reason, it took the Common Pleas Court over 6 years until September of 2014 to finally vacate that default. So the notion that my clients sat on their hands and were dilatory is a complete flip-flop from the position that they took at the beginning of the case, which was that this case was premature. I want to sum up by basically circling back to where I think this case begins, which is my clients unquestionably are 50% owners of the oil and gas rights in property. There was a default judgment that was later vacated, but by reason of the default judgment, Deer Park sold a very valuable, for over $12.6 million, oil and gas rights, half of which belongs to my client. The Common Pleas Court, Superior Court, got it right when it said that the claims were timely filed. There is no statute of limitations which expressly governs this type of claim, whether statutory or common law. and they are entitled to their 50% ownership rights in this property. And if the court has no further questions, I would sit down.
Thank you. I wanted to point out for the students that you've heard advocacy from two extremely experienced and outstanding lawyers who are in our Pennsylvania bar. How many times do you reckon you have argued before our appellate courts, Mr. Rublin?
20?
20? And how about you, Mr. Elliott?
Probably 40 to 42.
And if you count the Third Circuit, then I'll double it.
We'll count that. Yes, it just...
We don't really count the third.
And you'll double it then,
Yes,
too.
and
You will then double it also, will you not? If you count the Third Circuit, you would double the amount of appearances.
Yes, well, my point
Looking out for your interest.
My point being that it's a pleasure for us and for the students to hear from such experienced and outstanding advocates. So thank you both.
Thank you.
Speaking of outstanding counsel, I'm sorry about the loss of your great partner, David Patinsky.
I appreciate that, Justice. David and I worked together on a number of significant cases, some of which came before this court, and it was a very surprising and devastating loss. He was a very young 81. He already had his next trip planned to France, and I miss him deeply.
Well, he argued the Marcy's Law case in front of us not long ago.
Yes, I know, and he was disappointed with the outcome, but he had the opportunity to make the argument, and he was pleased. I want to thank Chief Justice Todd for referring to me as experienced and not old.
Oh, I'm very careful about that.
Yes.
Thank you both.
Thank you.
Just supplement Justice Weck's comments on David Patinsky. He, as you know, was one of the leaders of the Dilworth litigation group with my brother John, who sadly predeceased David, but not by much, and they were two giants.
Yes,
Very sad.
Yeah, Dilworth spawned a lot of great lawyers, the Dilworth firm.
Yeah, that's right. I think Bruce Hoffman, who's now gone to the
Right.
board, David, John. I did talk to Ed Menino, and he said he could be the last man standing. Thank you very
All right,
Thank
thank
you.
you.
Thank you.
Thank you.
both.
Thank you.
Mr. Minner, would you call the next case?
Earl and Christine Dwyer versus Ameriprise Financial. Representing the Dwyers, Mr. Kenneth Barron. Representing Ameriprise and all of his happy conduct.
In this discretionary appeal, we must determine whether a trial court may consider a plaintiff's receipt of counsel fees, costs, and common law punitive damages in deciding whether to award treble damages under the Unfair Trade Practices and Consumer Protection Law. We must also assess the proper standard to be applied on appeal when reviewing a trial court's decision to refrain from granting treble damages under the law. You may proceed.
Sorry, my throat's a little dry.
No worries. Good morning.
That was that Justice Kavanaugh problem.
Exactly.
The water thing.
I'm glad they have it here, though. Madam Chief Justice and Justices of the Supreme Court of Pennsylvania, the issues in this appeal resolve around I'm Ken Barron, and I'm here on behalf of Earl and Christine Dwyer.
Thank you. We know who you are, but it's good to state it.
Yes,
Thank
my
you.
apologies. The issues in this appeal revolve around a plain reading of the statutory language of the private right of action under the Consumer Protection Law. 3 points I'd like to make about that. First, a plain reading of the statute shows that remedial damages are to be awarded in addition to common law remedies. Second, discretion provided to the trial judge in a statute must be exercised within the context of the legislative purpose of the statute, and that discretion is limited to the statutory purpose, which I believe is what Your Honor, Justice Weck talked about in the Clean Air Council case, about what is statutory discretion. Third, the exercise of that discretion to award the remedial damages involves a consideration of 4 guideposts, which are different discretely and separately than punitive damage, the guideposts for proving punitive damages. In this case, whether deciding whether to award remedial damages, the trial court considered or failed to consider the statutory guidepost. Instead, the court considered the award of common law punitive damages as a sufficient amount to dispense with the statutory considerations.
Therein lies the nub, because how do we define discretion? That certainly seems to be within the trial court's discretion.
Absolutely not.
Okay, let's hear why.
Well, we'll have to go back to Judge Dweck. Gabriel versus O'Hara, decision Your Honor wrote. I argued that case, and unfortunately I did not win this issue. I thought that juries should be able to decide consumer protection issues. And the decision came down clearly that it is the court that is responsible to decide consumer protection damages. The court cannot then defer their discretion to a jury awarding common law damages.
That doesn't precisely answer this question, does it?
Well, it gets to the point that when there are remedial damages provided in a remedial statute, a court cannot ignore the entitlement to those remedial damages. You can't substitute them with common law remedies. If you substitute them with common law remedies, then what's the purpose of having the statutory remedy? Why did the legislature even put those remedial damages in the statute?
I can tell you.
Well, but the point is that isn't your point in that regard that the trial judge here could have said, you know what, in my discretion, I'm not going to treble the damages, but what he couldn't do is force an election of remedies because they're different species of damages.
Exactly.
Isn't that the point?
But yes, that's step one, absolutely. There's a second half of that, though. When you look at Schwartz v. Rocky, this court has already said that remedial damages or treble damages are remedial. They're not common law. They're not punitive in nature. So that's where you get to the two different types of damages. But there's an additional point that this court gave a specific example of when trebling should occur, and it's one of those 4 guideposts. Was there intentional misconduct by the person or the entity, that violated the statute? That is the one time this court said, you must treble damages. The judge here said, I'm not trebling damages because there was intentional misconduct. I'm looking to common law remedies rather than what the legislature told me I must consider in awarding remedial treble damages.
Consider. To me, that gets back to discretion.
Discretion is tempered by, and contextual within the statutory goals. The statutory goal here is focused on the consumer. Step 1, show a violation. Step 2, the focus then shifts to what remedies should be provided to the consumer.
But that's process. That's not statutory goal. What is the what do you believe are the statutory goals of the Unfair Trade Practices Consumer Protection Law?
Eradicate the monumental properties case. Eradicate the use of unfair and deceptive business practices. That's what this court said is the purpose.
So there's certainly the idea that you want to remedy, that the statute wants to remedy these harms, right? So that's a purpose,
right? And okay, well,
and the statute wants to incentivize consumers to bring these actions because sometimes the damages are very small, but you don't want to have, you want to incentivize lawyers to bring them, you want to incentivize plaintiffs to bring them, and if their only actual damages that they could prove to a jury are like $1,000, they're going to have a hard time finding a lawyer. So that's another purpose of the statute. And then deterrence is probably the third.
Well, fully compensating consumers for ascertainable losses.
I said that. I said recovery for damages.
Well, but it's broader than actual damages, though.
Oh, what do you mean it's broader than actual damages?
Ascertainable losses include a lot more than just the actual damages. For example, cases all throughout the country talk about what are ascertainable losses. They include such things. The U.S. Supreme Court said, treble damages make the remedy meaningful by counterbalancing the difficulty of maintaining a private lawsuit.
That's an ascertainable lawsuit.
I agree. Okay, so I agree with you that I'm trying to understand. So a judge looks at all of those things about the statute. First of all, your client did get relief under the statute. Your client got attorney's fees and costs. So that's part of this statute that you're saying the trial court didn't apply. The trial court gave you attorney's fees and costs, right?
Yeah, but the trial court used that as an offset against awarding treble damages.
I understand.
That goes against this court's decision in Grimes.
We might disagree on that.
Grimes specifically says, just so we're clear, that attorney's fees are awarded in addition to treble damages.
Oh, if you award treble damages, but it doesn't mean okay.
It doesn't mean you have to award them.
My point is, I guess my question is, the trial court, you're saying that the trial court cannot look at something, look at the award, that you have to ignore the fact that there's already a monetary award of damages against the defendant here. You're basically saying we ignore that and you get a whole new trough of damages. But the statute says treble damages. What are you trebling off of if you don't know what the damages as determined by a jury are?
No.
You have to treble off of something.
The actual damages.
Right.
And what the treble damages provide for is the additional relief to cover the ascertainable losses, which are greater than the treble damages.
If, in the trial court's discretion, the purposes of the statute, incentivizing the lawsuits, recovering the actual damages, and deterrence are not satisfied by just the regular award.
Exactly.
Right.
Yes.
So the trial court seems to have said that. The trial court looked at what your client got and said, I don't see any additional award necessary because the award is sufficient to incentivize the bringing of these lawsuits. The award is sufficient to remedy the wrongdoing, and the award is sufficient for deterrence.
I don't believe he said any of those elements. He just went to, you got enough money, or the defendant has paid enough under the common law punitive damages.
I see no reason to give you the additional bump that the General Assembly said I can give you.
But then he did not consider what the General Assembly, what the purpose of the statute was. He just said, there's enough money paid by the defendant that can serve as an offset. Look, you got punitive damages, you got attorney's fees, and you got your actual damages. Therefore, I'm not considering treble damages. That's not how these statutes work. That's not why the legislature put into place the purpose of providing for treble damages. They're to look at incentivizing bringing the claim.
Well, are you saying that in the absence of treble damages here, let's say the statute didn't exist, your client wouldn't have been incentivized to bring the suit?
I think they would have brought the lawsuit because they were defrauded and lied to about their life insurance policy.
Right. So this wasn't like a nominal damages case where you needed the treble damages to incentivize your client to bring the suit.
No, I believe that they went through a lot. Just so you understand, with my clients, they lost existing insurance policies that were perfectly fine, whole life policies, growing in value, traded those in, cashed them in, and put them into this universal life policy, which then eventually just wiped out all their money. So at the end of the day, when you put your money into a life insurance policy, there's no income taxation to that. So they get a damage award, they get their money back plus interest. So they're not actually financially backwards because the interest is taxed. So they actually are in a financially worse position than if they had never been defrauded in the first place.
But, counsel, that's not the purpose of treble damages. I mean, just my view of this, I think the trial court erred. Not because there was no award of treble damages, but because of the trial court's lack of consideration of the fact that treble damages are at least in part there to recognize the fact that these are private citizens acting as private attorney generals to do away with unlawful conduct. This isn't your ordinary tort action. This is a situation where the legislature said that it is unlawful to do what the defendant in this case did. And consequently, the trial court has to consider not only attorney's fees, but also the fact that these private plaintiffs took their time and energy to prosecute unlawful conduct.
Yes.
The trial court could have awarded nothing. Could have awarded nothing. But in awarding nothing, it would have to been in the context of consideration of the purpose of treble damages.
Correct.
So, I mean, in my view, you could go back and still get nothing, but it would correct the predicate for a trial court's analysis of whether or not treble damages should be awarded. And attorney's fees don't fix that.
Correct.
That compensates you.
Yes.
And it doesn't take money out of their pocket, but it doesn't compensate them for their effort in being a private attorney general.
Correct.
But
Absolutely.
doesn't the award of punitive damages somewhat overlap with that purpose?
No, in no shape, form, or manner, none
Because
whatsoever.
one's common law and one's a statutory remedy specifically, and you just don't lump it all together in one piggy bank and say you got enough money. Isn't that the point?
Yes, and on top of that, punitive damages are sort of more of a form of rough justice. Yeah, we're going to award a certain. There's no set defined why you get punitive damages. The remedial treble damages are specifically tied into actual damages. There's a concrete number to base that upon.
That's the word treble.
Precisely, as well as the fact that the legislature knew that common law punitive damages existed when it passed this statute. So why'd they do that? They didn't do it for superfluous reasons.
Well, why did we then say that you have to look at punitive damages factors to determine whether to give treble damages?
Because, again, that's a good question. There's two paths here. Punitive damages, you focus on the wrongful conduct of the wrongdoer, whatever that is the purpose of punishing that person. Remedial damages, there's no element of punishment. One of the factors the court may consider, though, amongst the incentivizing the individual, private enforcement of the law, one of the factors is, again, eradication of unfair, deceptive, and business practices. So,
Level the playing field, like Shapiro said.
yes, leveling the playing field, and by looking at the punitive, the wrongful conduct, first establishes a violation, but then secondly, how do you enforce the legislative goal of saying to the marketplace that this specific sales practice is improper? And by the way, millions of people were sold the same way deceptively as happened to the Dwyers all across the country. You have class actions against Prudential, Metropolitan Life, New York Life, Ameriprise, etc. So we're not talking in a vacuum here. And by the pronouncement by a judge to the market at whole that this particular sales practice is a violation of our Unfair Trade Practices Act sends a different type of message than just an award of punitive damages.
Well, the trial court did say it's a violation of the statute.
Correct, it did, but then it did not consider the remedial purposes of the statute in determining whether treble damages should be awarded.
So again, I mean, we have to have this base of actual damages to award the trebles, right?
Correct.
And we know what the actual damages as determined by the jury were.
Yes.
Okay, the trial judge, you're not saying under the discretion of the trial judge has the discretion to set a different floor for trebles.
Well, we agreed ahead of time with the parties to say, look, we're going to let the judge pick the common law damage number, the actual damage number.
Okay, but
so there wouldn't be any confusion.
So you're saying in this, so I'm wrong on the facts. In this case, the judge set the actual damage.
Yes.
Floor. Okay, a jury could have.
They could have, absolutely.
Okay.
Absolutely.
But you have an actual damages floor. But under the statute, you're not suggesting that the statute gives the. Let's say the jury did decide that. You're not saying that the judge can set a different floor for purposes of treble damages.
No, there has to be some consistency.
Okay, so you have an actual damages floor, and you're saying that the judge then has to look at that actual damage floor and look at the purposes of the statute, the incentivization, the remedial aspect to it, and the deterrence. Mm-hmm. And then once he looks at those, looks at the actual damages, he can say, I should give trebles here because I don't think the actual damage figure is adequate to accomplish the purposes of the statute.
Correct.
And you're saying the trial court judge didn't do that?
Yes, absolutely, he did not do that.
Okay. So we should send it back to the trial court to say, look at the actual damages figure, ignore the punitives, ignore whatever, and determine whether that actual damages figure alone is sufficient for the three purposes or however many purposes we articulate of the statute, even though one of the factors we said in the prior case is a punitive damage aspect.
And again, under the statute, when you look at the punitive aspect of it, you're looking again with the mindset and the focus of providing a remedy to the consumer. And that, you know, the wrongfulness of the conduct, that is the deterrence factor of the statute. I understand it. It feels confusing. It feels awkward. But solely punitive damages are one direction.
It's only awkward to me a little bit in the sense that, and you know, I understand the court's precedent on this question about the treble damages. It feels awkward to me because it feels like the General Assembly gave the trial court a fair amount of discretion in this area, and we are being asked to fill a gap in terms of setting forth greater standards than what the General Assembly chose to set forth with regard to the trial, and greater limitations than what the General Assembly set forth in the statute.
No, I don't feel that way at all. I understand where you're coming from. I've gone through that.
I didn't expect you would feel that way.
Well, but I've gone through that exercise, trying to figure out where should this lie. I mean, I've been doing consumer protection cases since the 1980s. And so this issue's in this case, I'm so happy we're finally here. It's taken a long time to get to this point, to get this issue resolved for all the parties can look at it, all the courts can look at it. What should be the standards the court follows? And there's a body of case law going back to the U.S. Supreme Court in the 1890s saying that treble damages are provided for to enhance or incentivize an individual for the private enforcement of the law. We've never actually said that clearly by this court before.
It seems to me you're saying that, contrary to what Justice Brobson was asking you, and I'm not quite sure what your answer was.
And we haven't quite got there yet, but sorry.
I apologize, but I'm trying to understand your answer.
That's fine.
It seems to me you're saying that even if we remanded it, the trial judge really couldn't say treble damages 0.
Yes, you could.
Well, I would say that if you're to remand the case, that you would say that.
Because I think he can, but I thought you were arguing here that he can't.
In the light of the facts of this case as they have been developed already, there's no need for the judge to articulate, oh, yeah, it was intentional, yeah, it was this, yeah, it was that. I think what has to be said is the guideposts the court should have followed are the following, 1, 2, 3, 4. The evidence supports all of that. Send back for recalculation of the treble damages amount. I think that in a certain degree the trial court maybe his hands are tied because the evidence has already come forth and has already established, number one, that under Schwartz, because there's intentional misconduct, the treble damages should be awarded as treble damages.
And of course, we all realize it's not only about this case. For us, for you, it is.
Yes.
For us, it's whether we find it to be legally incorrect to conflate these two species of damages, or to assume that the common law punitive damages is somehow subsumed or tied up with this statutory analysis of trebles. That's right. Going forward, that's going to be the important legal question, right?
Exactly. No, and I think that line needs to be drawn so that it's clear separation between the two. You can never use common law remedies, period, to figure out a remedial damage.
Except for the floor.
Except for common law actual damages. Actual damages, right, I agree. The Hoy v. Angeloni case, this court has already pronounced, you cannot use punitive damages to serve the remedial purposes of a remedial statute. Yet that is exactly what the judge did here. He used the punitive damages to serve the purposes of the remedial statute. You get back to the question then is, why did the legislature put into place specific remedies to be provided under the statute if all the judge has to do is say, I'm going to defer my discretion to the jury and let the jury decide how much should be awarded to cover the treble damage aspect.
Look, I completely understand your argument. I think this is a difficult case. I think our prior precedent in this area, I think, is interesting. I'm struggling for the word. I do think, though, that the reason why the treble damages is there is really thinking about a jury deciding a common law case and saying to the General Assembly, saying to the Judge, we know the jury is going to decide these common law issues. If what they do is inadequate to address the statutory purpose, we are giving you the statutory discretion to treble or double or 1.5, whatever it is, or 1.1. We're giving you that because you can't interfere with the jury, but we can give you this authority to gin up the damages to make this meaningful.
Except that there is no language in the statute that authorizes what you're saying.
Well, I'm not sure there's language in the statute that puts the cabining on the discretion of the trial judge that you want us to do either.
No, that is clearly set forth in the Clean Air Act Council case, how you're supposed to look at statutory discretion. It's not absolute discretion to do whatever at the whim of the trial judge. It is cabined by the requirements of the legislature provided in that statute. What was the statutory goal of that statute? And it has to be viewed, the discretion, within those confines. Here, all that they did was say you have the ability to award treble damages, and that you're supposed to look at the eradication of unfair and deceptive business practices. As this court has said, you can look at intentional misconduct as a basis for trebling damages. Nowhere does it say you can look to the common law or any remedy under the common law.
But it doesn't say you should ignore the damages that the plaintiff got.
No, it says you shouldn't consider them at all. That's not a consideration, period. If there was no, two scenarios, no common law claim at all, okay, we don't have to worry about it. What if here that we had one everything and then the punitive damages verdict was reversed? And the trial judge based his whole decision on the punitive damages, and his determination made after the fact that, oh my goodness, there weren't sufficient facts to prove by clear and convincing evidence that punitive damages should have been awarded in that case. So now you have a verdict you can't change it, that no treble damages were awarded because of something the jury did in the common law.
That's a good point.
That's why they have to be separate.
We have a difficult decision to make on this case. Does anyone have any other questions for Mr. Barrett? All right. Thank you very much, sir. Let's hear from Ms. Kondo.
Thank you. If it pleases the court, Kathy Kondo on behalf of Aplts.
Ms. Kondo, could you pull the microphone
Sure.
down? Thank you.
Is that better?
Not quite as tall as Mr. Yes.
Does that work better? Okay, thank you. I'd like to pick up where the last argument left off. In the Schwartz case, which has been alluded to, this court specifically noted that the statute provides no factors, provides for discretion, uses the word may award up to treble damages in its discretion. Because of that, this court in Schwartz specifically looked at what factors the court was going to apply. And it noted that it would look to the purpose of the statute. And as I think it was Justice Brobson reminded us, there are three purposes: remedy harms, incentivize consumers, particularly in the situation of very small nominal claims, and deterrence. In fact, the Schwartz court noted those same things. The Schwartz court said, quote, "On the one hand, the trebling of damages obviously has a strong punitive dynamic. On the other hand, many individual claims asserted under the UTPCPL will be small. Thus, it seems reasonably likely that the legislature, which wished to enhance the impact of monetary awards under the statute to deter wrongful trade practices affecting the public at large." This court in Meyer reaffirmed that there's a deterrent and punitive element to treble damages under the UTPC.
It talks about an element and a...
I'm sorry, Justice. Yeah. Mr. Barron made a good point, though, about what if on appeal the punitive damage award is overruled and the judge has not, or is reversed, and the trial judge has not awarded trebles on reliance on the punitive damage. I mean, that seemed to me to be a provocative question.
Well, I mean, first of all, obviously that's not what happened here, but I don't think there would...
but we're not deciding for this.
I understand. I don't think there would be a final judgment. If you have a situation like this, where you have a common law jury claim, as well as a UTPCPL claim, which sometimes you do have both, sometimes you don't, right? But if you have that situation, I don't believe you're going to have a final judgment on the UTPCPL until whatever the common law issues are tried. So I think that could be, for lack of a better word, remedied if it turned out that the punitive damages were no longer available after an appeal.
It would affect the whole damage award.
It would affect the whole damage award.
Possibly, yes. And I interrupted Justice Wecht. Please proceed.
Thank you, Chief. So, you reference language from prior cases about a punitive dynamic or a punitive element, and I wonder if that kind of language has led courts, the trial court in this case, astray from the principle that this is a consumer statute which stands apart from the age-old common law remedy of punitive damages. The jury does whatever it's going to do or not do in its discretion over here. And then here, the trial judge can elect not to treble the damages, but it seems to me that what he or she cannot do is say that the jury opened up a can of whatever on the defendant, so you're taken care of, because analytically it's a separate calculation, because otherwise all you get is basically a volume discount on outrageous conduct. I mean, you get sort of a cleaving off of a statutory remedy ab initio because the jury decided the conduct was outrageous, which doesn't seem to be consistent with the consumer statute. In other words, long story short, the trial judge could have said, I'm not going to treble, and here's why, but can't say, I'm not going to treble because you were made whole by the punitive thing at common law. What am I missing here?
So what the judge did was he addressed the three purposes of the statute that Justice Robson recognized. He looked at whether the harm has been remedied. Here, these folks paid approximately $14,000 in premiums over the course of 34 years. They had insurance coverage over the course of those 34 years. And they got those premiums back, so they got $14,000 plus back, plus 6% interest. The trial court refused our request for a set-off out of that money for the benefit of the 34 years of insurance coverage they got, and so he recognized that in his decision on treble damages when he was looking at whether the harm was remedied. He said they got their premiums back, they got 6% interest on them, they had insurance coverage for 34 years. I did not apply a set-off because he was also the determiner of the actual damages. And so he looked at that. He looked at the fact that they got Mr. Barron got $100 and some thousand in attorney's fees, which of course benefited the plaintiffs because they didn't have to pay out of pocket for any attorney's fees. So that money was whole for them. And then he also looked at the fact that they were going to get an additional $75,000 in their pocket. So he looked at that with respect to whether the harm was remedied, the first factor. Although he didn't talk about it, I think we can all agree that this was not a case of nominal damages that the Schwartz court was talking about with respect to the need to, incentivize these nominal claims. And then he looked at the third element or purpose of the statute, which was deterrence, and he said that the total award sufficiently compensated them for their losses, and the total award sufficiently punishes and deters defendants from engaging in similar conduct in the future.
Yeah, but the problem is the deterrence focus in the unfair trade practices and consumer protection law is not necessarily the deterrence of the defendant. It's also a deterrence of other companies engaging in the same conduct in the future.
I agree that there's let's call it a dual purpose. Certainly you want to deter the defendant, and there's also a purpose of deferring or deterring other companies. But I'm not, but when we're talking about deterring other companies, I think we're talking more about the private, or I'm sorry, the public. The Attorney General has, of course, a public cause of action in the statute. I'm not sure that, trebling damages on this award and having Ameriprise pay, $80-some thousand in treble damages is going to deter the industry, if you will. I think the deterrence, beyond the deterrence of the defendant, is more likely going to come from the public aspect, the public enforcement aspect, which of course is a critical part of the Unfair Trade Practices Act.
Can I ask you a question about?
Sure.
And I think the Chief Justice asked this tying to the common law. Let's prepare in our minds a case that doesn't include a common law claim.
Okay.
It's just the unfair trade practices claim, which happens. The statutory claims may exist on their own. Does the Unfair Trade Practices and Consumer Protection Law allow for punitive damages?
No.
Right. So the General Assembly's intent, if they wanted to award punitive damages, could have been to create a punitive damages remedy. But what they did was create a treble damages remedy off of actuals. If that's true, then isn't Mr. Barron right that you need to examine the statutory claim by itself, divorced from the common law, to evaluate that unto itself? Because if it were just unto itself, we wouldn't be looking at a punitive damages award. And again, I think it's been set up here, we're trying to figure out how this is supposed to apply in every scenario.
Sure. I think the problem with, and I think we can't talk about that without addressing an issue that is not before this court. It was not before the trial court or the Superior Court in this case, which is the election of remedies issue. So in this case, just to be clear on procedurally how this occurred, the trial court decided in 2019 the unfair trade practices claim after the jury trial. And that had been agreed to by the parties that that's how this was going to occur. And then the judge, as has already been indicated, was going to make an actual damages award that was going to be for the common law claim and for the UTP-CPL claim. The reason that was done was because there was this set-off issue that we had raised and that ultimately the trial judge rejected. But the thought was that it wasn't clear if that set-off issue was a jury question or a question for the judge. So we just decided to allow the judge to determine it for both the common law claim and the UTP-CL claim, which he did, and he did not, as I indicated, he did not give a set-off for the insurance coverage that they had gotten for the 34 years. So in 2019, after the jury trial, he makes the UTP-CPL verdict. Actual damages, makes his treble damage determination, and makes his attorney fee award. Then in 2020, long after that, we file a motion for election of remedies. And our position and argument in that motion, which was denied, was that the plaintiffs had to either select their UTP-CPL verdict, which would have gotten them actual damages and attorney's fees, or they had to select their common law verdict, which would have gotten them punitive damages and actual damages, but no attorney's fees. That was denied. And so there is no issue before, there was no issue before the Superior Court, there is no issue here as to whether, for instance, if the judge had decided to award additional damages up to treble damages, whether the plaintiffs in that instance would have been permitted to recover both that amount and punitive damages. So that issue, which is, I'll use the word out there, it's clearly not before this court. It was not before the Superior Court. It's not been briefed.
So we
I say that,
so
I'm sorry.
We have to be careful is what you're saying.
I am. And I'm also, I guess, saying, in partial response to your question, that it sounds a little bit like a potential election of remedies kind of question that you're asking, which is not at issue here.
Well, you can call, like, I think I see what you're saying. You could call it, you could call it an election of remedies or not. But the issue that I think is pretty clear is that the trial court, and again, you're arguing that it's okay. I mean, but and Mr. Barron's arguing it's not, is that the trial court felt it could use the punitive damages awarded by the jury in common law to substitute for any treble damages that otherwise might have been awarded. And that's where I keep coming back to this analytical disconnect, because if the trial judge had set it up like, I'm going to deny treble damages for X, Y, and Z reason, we'd have a different case. But here it seems like he said, you know what, you got your rough justice with this punitive damages hammer, so you don't get the trebles. And I'm still struggling to see how that fits in with the statutory scheme.
So I guess two things. One, Mr. Barron talks about substituting. To be clear, the trial judge never talked about substituting. He never talked about offsetting. Mr. Barron talks about that. Again, what the trial judge said is that the plaintiffs were adequately compensated for their losses, and the total award sufficiently punishes and deters defendants from engaging in similar conduct in the future. Now, Mr. Barron would say, well, when he says the total award, he was clearly, talking about the total award, which includes the $75,000.
Well, how can you say it's not? Are you saying it's not?
No, I'm not saying it's not, but I'm saying he's not saying he's substituting anything, he's offsetting anything. He is looking at the reality here. This is not a hypothetical $75,000.
No, but it may be a temporary reality, and you still haven't answered the Chief's question, which I think was Mr. Barron's finest argument, which was, let's say we allow this to happen, and we can say a trial court judge where a common law claim exists and an unfair trade practice, a statutory claim exists, says the reason why, or a reason, maybe it's a part of a reason, the reason why I am not trebling actual damages here is because of the total award, your words, which I think Justice Wecht is right. We have to say it includes the punitive aspect.
Sure, and I agree with that.
And then on appeal, the Superior Court vacates the punitive damages award and says, does it go back to the trial court to recalculate the question of trebles, or is the plaintiff out of luck?
No, I think it does. And that gets to a critical point here, that I would be the first to agree that the for the trial court to consider the punitive damages as part of its consideration of those three factors we just talked about, those punitive damages have to be payable/paid. He can't consider them if they're not going to be paid.
Well, but he doesn't know what the Superior Court's going to do on appeal.
Well, but there was no appeal here with respect to the punitive damages, and if there were to be an appeal, then this is going to be part of a total damages verdict. So I don't know how it would be procedurally possible to only appeal the punitive damages on the common law claim, because remember, in order for the court to consider the punitive damages as part of the total award, they have to have already been awarded. If they haven't already been awarded, of course he can't consider them. There's nothing to consider. Here they were awarded. I would submit that in any opinion from this court, an obvious caveat to this would have to be that the punitive damages have to have been awarded for them to be considered, and they can't be temporary or potentially temporary. They can't be subject to an independent appeal, because that would not be fair.
Counsel,
yes,
I'm just having a hard time in reading the statute on its face.
Okay.
Why would we take into account any other damage award based upon any other cause of action? I read this statute as a box here is what a private action entails. Here's what the damages are for that private action. It makes no reference to really other considerations. I mean, this is a self-defining cause of action, so to speak, with self-defining remedies.
I think the answer to that is that you can't look at the discretion in a vacuum of what we know to be the real facts. The real facts here being that for this same claim, these same actions, this same party is being paid by the same defendant $75,000. And we can't ignore that. Or a trial judge can choose to ignore that, excuse me, but we can't cabin his or her discretion and not let him consider that. And I would just
why is that? And I get back to my question. As I read the statute, it sets forth what can be awarded for an unlawful act as defined under Pennsylvania law. And it just sets forth what can be awarded for that unlawful act. I don't disagree that in considering these elements in the trial court's discretion within the context of the damages awarded within this act, he or she does not have to award treble damages, but I don't see how you look outside of the statutorily defined cause of action, because it tells you what you get for that violation of law.
But it doesn't tell you what factors you can look at when you exercise that discretion. This court has said that the factors you look at are the three that we've sort of identified ad nauseum at this point, and you can't just ignore that there's going to be a payment made of $75,000. You can, and I keep saying that. You can. The trial court can ignore it. What I should say is, you can't tell the trial court that they have to ignore it.
But just to follow up on that,
yes, we can.
To follow up on that, aren't you in answering Justice Donahue that way? Aren't you ignoring that the punitives were awarded by the jury on common law claims, whereas the statutory action was tried to the court, and so there's an actual damages award, and then the court has to make his own analysis and decide under the statute, am I going to treble it or not? And your argument now that he can just lump in sort of this gestalt or sort of the overall flavor of the thing based on what the jury did on common law claims, it seems that, apropos of what Justice Donahue said, it's a separate box over here.
It was the same claim. So the common law claim was...
No, it's not. See, that's I think where we're making a disconnect here. This is a very specific statutory private action. And in the context of what the General Assembly did here was say, if there is a violation of the law as defined in the Act, then here are the elements of damages that can be awarded, period. Now, to superimpose on that damages that are awarded based upon a separate cause of action doesn't jive with what the statute says is supposed to happen in this case.
So this, first of all, this was a pre-amendment case, which means that the plaintiff, in order to prove the UTP-CPL claim, had to prove fraudulent misrepresentation. It was pre-amendment, right? So the claim that was tried under common law to the jury was fraudulent misrepresentation. The claim that was tried, it wasn't independently tried, but that the judge then rendered a verdict on based on the evidence from the trial, was for fraudulent misrepresentation.
You could have reached a different verdict. In fact, in Gregg versus Ameriprise, we had a disconnect between the jury verdict and the bench trial, the bench verdict. So you, how that was just saying that you're saying it as if Judge Connolly looked at the jury and said, you found, misrepresentation, therefore I do. That's not how that works.
It was a post-amendment. The difference was Gregg was a post-amendment case. So That was very different.
Can I make
Yes.
just another point along
Sure.
your same line of argument? The fraudulent misrepresentation claim was an action in tort.
Correct.
This is an action based upon violation of the law. They're two different things. And consequently, they deserve two different considerations in terms of the award of damages, the statutory damages being defined within the private action section of the Act.
So, again, to go back to the distinction I think I made before, what the statute doesn't tell us is what are the factors that can be considered when determining treble damages under the statute. And if I may just pose a hypothetical. Let's assume that the $75,000 was not going to be paid by Ameriprise and flow to the plaintiffs on the basis of a punitive damage award. Let's assume that Ameriprise, of its own voluntary volition, but without getting a release, had agreed to pay the plaintiffs $75,000, as part of some earlier discussion, but with no release, and so the cause of action was still out there. Maybe you all disagree, but I'll say I don't think anyone could disagree that when, in this case, Judge Conley is making his determination on these three factors we've talked about, that he couldn't consider. He may say it matters, he may say it doesn't matter, just like he had the right to say the punitive damage payment matters or doesn't matter. That was, his discretion. That would be evidence that could be considered by Judge Conley in determining whether he, under the statute and in his discretion, should treble the damages. And I would, I'm sorry.
I don't know if that's true. I mean, under the construct as I see it, which is we have a private action for enforcement of the consumer protection law, the hypothetical that you're using better meshes with the situation. They make that payment, but the statute requires a $5,000 fine to be paid. I mean, they're just two different things. I didn't
mean to interrupt you. In my hypothetical, it's not a fine situation. My hypothetical, because there was no release, they would still have a right to and could get actual damages. This would just be an additional voluntary payment in my hypothetical. So it's really, again, in my view, no different than they happen to be getting this $75,000 from Ameriprise in this situation because of a punitive damages award. But the judge can consider that. He doesn't have to. I'm not arguing for an offset for it, not arguing for anything mandatory, but we can't cabin his discretion.
Okay,
and
I think we actually understand the argument, and as I said to Mr. Barron, it's a difficult question, and we will address it. Any other questions from the court? Thank you both very much.
And I apologize, I spilled some water here.
That's all right. That's all right. In fact, while she's cleaning, I did this. No, you didn't. It is. Thank you, Mr. Minner. Would you call the next case?
Vincent Sicilia versus API Roofers Advantage Program. Representing API Roofers was Jean Lombard. Representing Mr. Sicilia, Mr. Daniel Siegel.
In this workers' compensation matter, the claimant, who had been receiving total disability benefits, underwent an independent review evaluation to determine the degree of his impairment due to his compensable injury. The physician evaluator assigned to claimant an impairment rating based upon claimant's diagnoses established through earlier litigation. However, the physician found that the claimant had additional injuries attributable to his work-related accident, which, if included, would elevate his impairment rating above the 35% threshold necessary to receive total disability benefits. Thereafter, claimant's employer moved to modify claimant's benefits from total to partial. Ultimately, the workers' compensation judge found that the claimant had the lower impairment rating and rejected the higher rating as not credible because it was not based on the previously established injuries. On appeal, the Commonwealth Court relied on our 2017 decision in Duffy versus Workers' Compensation Appeal Board and reversed and reinstated claimant's total disability benefits, concluding that the workers' compensation judge erred in limiting its review of claimant's impairment rating only to claimant's previously established injuries. We granted this appeal to determine whether the Commonwealth Court usurped the fact-finding authority of the workers' compensation judge. Good afternoon.
Good afternoon, Your Honor. Thank you. May it please the Court. My name is Jane Lombard, and I represent API Roofers and the Pennsylvania Workers' Compensation Security Fund. We're asking the Court to reverse the ruling of the Commonwealth Court and restore the modification of compensation benefits to temporary partial disability status based on the credited 25% whole person impairment rating. And we have 3 reasons for asking you to do so. We believe the Commonwealth Court impermissibly expanded this court's ruling in the Duffy case, thereby usurping the authority of the workers' compensation judge to decide the nature and the extent of the compensable injury. Secondly, we believe that the Commonwealth Court erred in impermissibly substituting their opinion of the credible medical testimony for that of the workers' compensation judge. And thirdly, we believe that this case offers the court the opportunity to bring the case law in line with the statutory directive in Section 306A.3. And doing so will eliminate the considerable confusion in the system between the obligation and rights of the IRE physician versus the authority of the workers' compensation judge, and doing so will restore the cost-saving objectives which underpin the impairment rating evaluation. So, with regard to the misapplication of Duffy, in Duffy, it was ultimately the workers' compensation judge that defined and expanded the compensable injury. Petition for review was brought, and the workers' compensation judge, after accepting competing medical evidence, decided that the injury included a psychiatric component. In this particular case, it was the impairment rating evaluator that, without taking any competing evidence, expanded the scope of the lumbar injury from a lumbar strain to lumbar disc protrusion versus spondylolisthesis and lumbar radiculopathy.
And this was, the evaluator was a physician.
The evaluator was a physician, and the evaluator was certified to perform impairment rating evaluations, but the impairment rating evaluator must tether that evaluation to the compensable injury. And in this particular case, the compensable injury had already been established through the adjudicatory process. And it's the workers' compensation judge that is solely vested by the workers' compensation statute to decide the nature and extent of the compensable injury. The process set up in Section 413 allows the judge to take the evidence where there's a dispute that the compensable injury as defined on the notice of compensation payable is incorrect. So it's the workers' compensation judge who has that sole and exclusive authority, and it's the workers' compensation judge who is positioned to be able to do so.
Was there, and I think this is a big difference with Duffy, is there was no litigation over the scope of the injury. You can't have it in front of an IRE physician, which is a panel physician that is, you don't even get to choose. And there was no review petition challenging the NCP.
There was way back.
No, I know. I'm talking about here, though. I understand there were previous efforts to expand the NCP that were unsuccessful.
Correct.
I'm talking about procedurally here, which is different from Duffy. In Duffy, there was a review petition in front of the WCJ challenging, saying the IRE doctor needed to look at more because we have more injuries, and here no one ever argued, brought a review petition to the WCJ to expand the scope of the injury after the IRE was issued.
That's exactly right. And the Commonwealth Court said that they didn't have to because under Duffy, they have such expansive authority to look at impairment and decide effectively what the compensable injury is, thereby thwarting what had been established way back when by Judge Baker in 2003 that said these are the compensable injuries in this case. And the injuries were then completely recasted by the IRE physician.
What are you asking us to do with our Duffy decision?
I think in light of how the Commonwealth Court impermissibly expanded the holding, you have to reverse Duffy. And I think that doing so will bring the clarity necessary back to the statutory objective. If you look at the language of Section 306A.3, it ties the obligation of the impairment rating evaluator to rate impairment secondary to the compensable injury, and specifically says you don't rate non-work related conditions and you don't rate pre-existing conditions. You tie that to the compensable injury, and then the compensable injury is either that which is on the notice of compensation payable, or if there has been litigation, it is that which is defined by the workers' compensation judge.
I have a question. It's kind of a factual question, and I'm just not really sure. If the claimant goes to the IRE doctor and I'm just using an example, and the injury was a laceration, and the IRE doctor says, well, now you have a laceration and you have an infection. Is that an issue?
If the infection is subsumed within the laceration, no. If they're still rating,
It's spread out into the bloodstream, and
if it becomes a different compensable injury, different than that which had already been defined, then it could potentially be an issue. I mean, in this case, what we have is an impairment rating evaluator who agrees that she is not rating the compensable injury, which is the lumbar strain, and instead is redefining it. If you have a lumbar strain that causes spasm, then you're still rating that same injury.
so in your position is the original injury was added to with a non-related additional injury.
Yes, but in this particular case, she didn't even rate the original injury. She said, I'm not rating the lumbar strain.
Well, she did. She just gave a low rating. I mean, she gave the rating that would trigger the statute and go to partial, which only means you're going to be on a clock. It doesn't mean your benefits are reduced.
That's correct.
But this difference between impairment and injury is really also the crux of the case. I don't think the IRE physician was suggesting at all that these new, she called them diagnoses. Typically, diagnoses are not impairment. I'm sure your opposing counsel is going to suggest that this was somehow an impairment and not an additional injury. But when I think about impairments, I think concussion is your injury, headache is an impairment.
Sure.
You would not call headache a new injury.
Correct.
Okay.
Correct. And I think that then brings us back to the fact that you have to tie it to the compensable injury. And you can't look at an expansive definition of impairment that ignores the compensable injury.
That's the problem that Duffy created.
That's exactly the problem that Duffy created, which is
Thus,
exactly...
Justice Weck's scathing dissent.
Exactly. You knew it.
I was going to say, I told you so.
You knew it. It's all playing out
But there's
right here.
there's an additional layer here, though, which was at least there was I mean, I have some concerns about Duffy as well, but there was at least some additional litigation before a WCJ over expanding the NCP in Duffy.
Right.
Here, there wasn't even that. It was we're just going to take what the IRE doctor said, and you're just kind of left. I mean, I guess my question is, didn't the claimant have a remedy here? The claimant could have petitioned to expand the definition of the IRE. You could have had a battle of the doctors.
I think...
Or not the IRE, the NCP. You could have had a battle of the doctors, and we wouldn't be here.
We couldn't have that in this case because that already happened back in 2003, and they were procedurally precluded from once again trying to do that.
We
But
could
in
have
theory,
we could have had it, and you would have argued administrative res judicata.
Yeah, correct.
But that would the only way you expand the scope of an NCP is to seek that relief in front of a WCJ.
exactly right, and that's 413. Yes. But even beyond that, if you don't want to get to the problems with Duffy, what the Commonwealth Court did in this case is substitute their judgment of the credible medical testimony that Judge Callahan gave for what they believed the credible medical testimony was. So Judge Callahan was faced with deciding, do I grant the petition for modification and find the 25% whole person impairment rating that Dr. Rodriguez felt constrained to give rating the compensable injury, or do I accept the 45% rating based on what Dr. Rodriguez thought that the compensable injuries should have been? And what Judge Callahan decided was, I believe the 25% rating, I don't believe the 45% rating.
Yeah, but see, I don't know that that's a coherent way to limit Duffy and, think it should be overturned, because it was that they weren't listed in the NCP, right? Well, that's what the WCJ had to say.
Well, the WCJ said, based on the long history of this case and the prior decisions, the compensable injury had already been established, and that's why I believe 25%, and that's why I reject 45%.
Well, but nuanced, and I think President Judge Emerita Leavitt articulated this fairly well, is the IRE physician, who was an IRE physician, with limited purpose, wasn't credible about the new injuries because there was a whole bunch of testimony and litigation where that was completely contrary to what she's saying.
Right.
And that's why the WCJ didn't find her credible.
That's exactly
Not
right.
really res judicata, but I can't believe I got an IRE doctor saying this when we've had all these physicians who have said this.
And we've had judges adopt it. Yeah. And the Commonwealth Court majority said that somehow there was this misapprehension on the part of Judge Callahan, but that misapprehension is nowhere in the record and is nowhere in her decision. She was fully aware of the circumstances that resulted in Dr. Rodriguez imposing the two competing ratings. So, again, I think Duffy should be overruled. I think that we need to bring clarity back into the system. I think that it's amply demonstrated in this case just how problematic the idea is that you give the impairment rating doctor this expansive authority. And of course, the Workers' Compensation Act is humanitarian legislation, and it's got that as its underpinnings. And in this particular case, what the IRE doctor did was benefit the claimant by precluding the cap on benefits. But it's very easily imagined that an impairment rating evaluator could lower the compensable injuries, thereby precluding an impairment rating that would get over the threshold. So I think, you have to look at it from all ends. And for those reasons, we believe that the decision of the Commonwealth Court should be reversed, and we hope that you do look at Duffy.
Thank you, Ms. Lombard. You can be assured we'll look at Duffy. Are there any other questions? Thank you very much. Let's hear from Mr. Siegel.
May it please the court, Dan Siegel on behalf of Vincent Sicilia. Overruling Duffy would, in effect, by this court, do what it has said as recently as the Keystone RX case it should not do, serve as a super legislature in terms of the IRE provisions. And it's important to note a couple of things. This court, not addressed in appellant's brief, is obligated, as was Commonwealth Court, as Chief Justice Saylor did in Duffy, to follow the Statutory Construction Act. And what we have here are two provisions of the Workers' Compensation Act that are distinctly different. And while Justice Wecht, in your dissent, you talk about the elephant in the room. The elephant in the room really is the chronology that has occurred in terms of impairment rating evaluations. And I'd like to just go through that, because what this court should do is clarify Duffy, affirm its essential holding, because Duffy affirms two concepts that are important: that the Workers' Compensation Act does have a concept of the accepted, the acknowledged injury. The IRE provisions use a different concept, and in doing so, empower the IRE physician to follow the AMA guides. That's exactly what happened here. What we know is that in 1995, Act 57 was enacted, creating the IRE provisions. The AMA guides, the 6th edition that led to Aplts, which had not been decided at the time of Duffy and is particularly relevant here. When that was adopted, the 6th edition was a sea change. Then Duffy is decided in 2017 with Chief Justice Saylor referring to the 6th edition, which ultimately in Aplts, this court invalidated. But what the legislature then did when it enacted Act 111 in 2018, it knew that this court had ruled in Aplts and had invalidated the statute as unconstitutionally enacted. It also knew that this court had adopted the decision in Duffy, including Justice Wecht's dissent. But what is not addressed, sort of the elephant in the room, is that Act 57 also readopted verbatim the language, and that brings us to the statutory construction issues here. The IRE provisions do not say that the IRE evaluator is obligated to address the accepted injury, which even in this case isn't something that's so simple, because while there have been various diagnoses and everything else, the history of this case is that the injury of a lumbar sprain is in addition to the fact that in one case, the employer here was ordered to pay for lumbar surgery, which is typically not treatment for a lumbar sprain, and addresses the question that Justice Mundy raised, that you have consequences. So now, with that context, let's look at the IRE provision, which is, as happens, we've seen it in pharmaceuticals, we've seen it in all types of other areas in terms of the Workers' Comp Act. The legislature enacts these provisions, but somehow doesn't really recognize that they don't say the same things. But the IRE provision makes sense when you look at it and look at it under the Statutory Construction Act, which says you have to give every word its plain meaning. What does it say? Act 57 said that the obligation of the examiner is to determine the degree of impairment due to the compensable injury. And then it goes on to say two different things, that it says that the impairment shall be the percentage of permanent impairment resulting from the compensable injury. And when we go to Merriam-Webster Dictionary, what do you see? The plain meaning of due to is because of, is resulting, is as a consequence of, which means that the Act 57 provisions, the Act 111, the new provisions, say that the evaluator is supposed to look at the conditions resulting from the work injury. It does not say the accepted injury. And if you adopt appellant's position,
it says compensable injury, and the only compensable injuries are the compensable injuries acknowledged in the NCP.
It says that, but what that your question does is remove the other provisions there, resulting from or due to.
Impairments resulting from or due to the compensable injuries.
Correct. And the AMA guides, and this is important, the AMA guides are not designed to look at a specific injury. They are designed to look at the impact of a condition on the whole body.
Yeah, but
and
Mr. Siegel, look, you want to divorce the AMA. You want to go into the AMA guidelines to override the statutory language of the General Assembly and the scheme of establishing a compensable injury. You're suggesting that somehow this. Look, you know this. You've done this a lot. Compensable injury is always an issue in front of an IRE because there are some IREs that will refuse to acknowledge the compensable injury. So there's tons of litigation out there in Commonwealth court decisions that basically say an IRE doctor must acknowledge the compensable injuries, stuck with the NCP. And if they don't do that, their opinion is incompetent and the WCJ cannot rely on it. You agree that that's the precedent?
I agree that there are those cases. Duffy, to me, is the precedent, as is the subsequent reenacting of the IRE provisions.
Why does it make sense that the opposite is allowed, that a WCJ can ignore the NCP to the extent the WCJ wants to create additional injuries not in the NCP?
Because the IRE is not creating additional injuries. It is evaluating the injuries and their impairment impact on the whole body.
Well,
Language.
The problem with the fairly attributable thing, it just never ends. I mean, there's an NCP, and it seems like you want to just divest this from the entire statutory process.
No, because as we know, the Workers' Comp Act is supposed to benefit the humanitarian purposes. That's to make certain that individual injured workers are compensated for their injuries. There is nothing more important to an injured worker than those vested rights that they gain when they have a compensable injury, in theory, to have benefits for life. The IRE provision limits those benefits to 500 weeks.
You can always, you can come back in. You have the ability to come back in for a petition to modify or a petition to expand the scope of the NCP. You didn't do that here.
I agree they didn't do that here, but that's because of the language in the adoption of the AMA guides that talk about.
I'm just saying, don't go down. I don't want you to go down. I mean, you can go down it, but I don't want you to go down this road that we have to ignore the entire rest of the Workers' Compensation Act to advance the humanitarian purpose of the statute. Your client had, if we would have followed the statute, and I see impairments and injuries differently. If we would have followed the statute, it's not that your client was out of luck and wouldn't have had a remedy under the statute. You could have done what they did in Duffy and filed a petition to modify the NCP and expand the scope of the injury. And it could have been litigated in front of the WCJ. And if you won, you could have petitioned to go to full benefits again, back from partial. And you would have only been out of your partial benefit weeks by, I don't know, a couple.
But your question addresses the central point here. We're talking about a statutory scheme that until the IREs talked only about compensable injuries. Once we had the IREs, we had a dynamic sea shift. And what we did was go from compensable injury to impairment. And they're not the same concept. The legislature, in its wisdom, whether we agree or disagree, and I was amicus counsel in Prats, they chose to adopt a separate scheme. And I don't believe that they are fully reconcilable. But what Your Honor's question presupposes is that the language that the legislature adopted, fully aware of Duffy, should be reanalyzed and essentially revised to say the accepted injury. The legislature had that opportunity. They chose not to do that. It's not this court's role to now say, well, we disagree with the wisdom of that.
Mr. Siegel, the litigation on this issue is IRE physicians must accept the injuries set forth in the NCP. You have argued that. I remembered you arguing that plenty of times. You're here arguing the exact opposite, that because of the AMA guidelines in the context of an IRE physician is free to add injuries or even take away injuries.
They're not adding injuries. They're not taking away injuries. They are addressing impairments that are a consequence.
Okay, so that gets to the point. Was the diagnoses that the IRE physician identified as additional diagnoses? I think the word was diagnoses.
They did.
Injuries or impairments?
I would say they're impairments. Because if you think about it, if you have a back injury, here, the lumbar injury with the resulting ordered surgery without a change in diagnosis, that surgery can cause a person to limp, can cause leg pain, can cause all types of things, just as a laceration could, in theory, and I've seen it happen, cause whole body injuries from an infection. Those are the result of, the due to, the because of, that the legislature, by adopting the AMA guides, empowers and is essentially directing physicians to employ.
What's the end of that process? I mean, and then you could, by extension, you could expand any injury and just say all we're talking about is an impairment change here. I mean, anything having to do with the back could be the same injury.
What has always been the standard in my practice, which is roughly 40 years of workers' comp, is that anything that is reasonably subsumed from that injury. So a back injury can have consequences. If you have a back injury, though, and suddenly an impairment rater also rates a shoulder problem, no, I would agree. That is not a consequence normally of a back injury. But we have always had in workers' compensation this tension between accepted injuries and when do you file a petition to review, when does an employer file a modification petition. That was the Jeans Hospital case. There have been lots of cases. And the practical reality is that you can't file a petition every time there is something that's a slightly different diagnosis, and in most cases, you would never see this because the IRE still, to this day, the 35% threshold is as high as any state in the country. It's not something that occurs often, but when it does, we're here because of, as Ms. Lombard referred to, the economic consequences of these conditions. Well, the economic consequences are also to that injured worker. And these are vested rights that they obtained as a result of being injured, and then suddenly they could have them removed because even though the injury description did not change, the consequence of the injury results in the impairment. Doesn't necessarily mean there has to be a new description of injury.
You say it doesn't necessarily, but don't you see the slippery slope problem? I mean, this is what ensues from Duffy, you know, when the majority talked about these overlapping and intersecting concepts. It's that conflation, you know, to refer back to Justice Brobson's questioning, this conflation of injury and impairment which allows the IRE physician to just expand beyond the WCJ's adjudication beyond any bound. There's no discernible principled limit on that.
The way I see this is that there's options for this court, which is always sort of the question that you ask. One is you could essentially affirm Duffy and clarify that it applies as to the plain language of the Act. You could also do as advocated by the employer here and essentially amend the provisions of the Act to say it's the accepted injury. But any interpretation that does that makes this court a super legislature, and that's not your role. You've refrained from doing that before. There is a wisdom and at times a questionable wisdom of what the General Assembly does. And none of us here is in a position to fix that.
So, Mr. Siegel, how could this have played out then? So the IRE physician is a panel physician. Neither of you get a lot of control over this. You can't present, evidence or argument to the IRE. The IRE physician can't go, hey, I'm considering this impairment. Here are the impairments I'm considering. What do you think? Nothing like that happens. The IRE physician issues the report. How does a employer or insurer get to litigate the question of whether the impairment is an injury or an injury is impairment, and when is the opportunity to present? Do you get another medical examination of the claimant? So the medical examination is in time with the IRE. I mean, tell me how that works.
I will answer Your Honor's question, but I just want to point out one thing. What the IRE reviewer did in this case is follow precisely the obligations under the AMA guides. And in particular, if you read sections either 2.3b or 3.2b, I get the numbers.
The question is not whether they follow the AMA guides. The question is whether they follow the statute.
That my answer of your question.
No, I mean, my question was purely procedural.
Right.
So tell me how it works.
Well, there's a remedy for the claimant. There is not in the Act a remedy for the employer. And the employer would be essentially bound by it. Presumably they could be creative, as they often are, and file something else. But in Keystone RX, a case we're all familiar with, I argued it myself, this court said that the absence of creating a remedy by the legislature does not give this court or any court the right to do that. The legislature created a remedy that enabled employers to, in times, modify benefits, and in most cases, it's most of the injured workers.
As a trade-off,
right?
As a trade-off for other things beneficial to the claimants.
I would question that analysis, but that's how they
historically. That's what the courts have recognized, and that it was a bargain. It was a grand bargain.
But at the same point, when they create these bargains, they don't necessarily give everyone equal rights. They didn't give medical providers equal rights, or we didn't believe so in Keystone. We've seen it in other situations. But here, they've given an employer a remedy that in most cases allows them to modify benefits, because it's the rare injured worker whose case would ever get to a 35% threshold. But that's the wisdom of the General Assembly. That's the wisdom or the questionable decisions when they write provisions such as this that use language that's never been used in other provisions. And either this court needs to give that language its plain meaning. The due to, the result of, are all the same words when you go to the dictionary, and the Statutory Construction Act says that you have to give statutes their plain meaning. I think it's section 1921 that unambiguous words must be given their plain meaning. And that's what this court should do here. Duffy was decided correctly, but needed clarification. There were the elephants in the room. There was prots coming down. There was, obviously at that point, no one knew what the legislature would do when it amended or if it reenacted the IRE provisions. They've done so. Those provisions haven't reached this court yet for a challenge, and I don't believe there's really any challenges on the constitutionality, so the provisions themselves are not likely to go anywhere. The legislature chose those words. Whether this court, would choose other words, I believe is for the legislature to decide, and it's for this court to enable the language of the act as enacted by the legislature to clarify the language of Chief Justice Saylor and reaffirm Duffy.
All right, thank you.
you.
Any other questions? Thank you, Mr. Siegel, Ms. Lombard. Before we adjourn to administrative session, I would just like to extend our thanks to PCN for covering these sessions so that we may have educational broadcasts. We really appreciate it. I'd like to also thank our court crier, Brian Minner, and our prothonotary, Caitlin Gorman, and our court security, Gary Shovlin and John Evans, as well as the Allegheny County deputy sheriffs for keeping us safe. Mr. Minner, you may adjourn.